Oh, komisia, mcaba komisia. Yeah, komisa, yeah. Hey, sheiks. Hola. Kim shagera, mcaba mshagera. I know it's not big. Eh? Yes, yeah. Yes, yeah. Yes, yeah. Yes, yeah. Hola. Ah, yes, yeah. Yes, yeah. Yes, yeah. Yes, yeah. Ah, yes. Laptop. Hola, 1, 2, 3. If I didn't that, if I didn't. We are about to start. Can we all be seated? Sure.
1 2 white wall ada white wall travel ura volume ore 1 2 1 1 1 2 1 Eman 1 2 1 1 2 1 1 hapa bulelo ra utu na ke maketsi ke bla go bolela ke skill 1 Eman o tsi ke bereka le motho a kho ban ga re kya Eman ba sa bulisa mo pike sure ya utlwala no 1 2 he 1 2 1 2 cheka volume ya mo one two ele Mr. Madina utlwala mo or no ba ke bela ke le one
ready to start the day's proceedings. Please make sure that your cell phones are on silent or switch them off. Thank you.
Good morning, Ms. Hassim. Good morning, Mr. Premhead.
Good morning, Chair. Good morning, Commissioners.
Thank you.
Morning, Chair. So before we begin with the witness today, we have one matter to deal with.
Yes.
And that is Mr. Karim's appearance.
Yes.
And I'll let my learned friend, Mr. Clement, begin.
Yes, Mr. Premhead.
Chair, I'm hoping that you and the Commissioners have the latest bundle which was provided to us this morning by the Commission, for which we're very grateful. But at paginated page... paginated page, the correspondence starts at 210, but the medical report in question itself starts at 212. I hope you have it. I'm seeing indications you do have it. I don't want to read bodily or facial expressions.
No, the minute you opened your mouth, my colleague, Commissioner Kumalo, said page 212.
Okay, perfect. I'm indebted. I'm also not sure if the commissioners have had a chance to consider the content of the report. I'm seeing indications there have been. And effectively, may I just ask you if you've got that report in front of you, to turn, and I'm going to take you to the end if you don't mind. I would take you to paragraph 20 at paginated page 225 of the bundle. Thank you, Chair.
Thank you.
And I point out that paragraph for two reasons. The first one is that gives you the state of Mr. Karim. And secondly, it then explains what has transpired or not transpired since the ruling of the 29th of July and why we are here in the way we are here. And I don't know to what extent I need to say anything more than that, but obviously I'm in the Commissioner's hands as to whatever issues might arise as a result of this report now being in front of you.
Thank you, Mr. Premhead. Do you wish to say anything, Ms. Hassim?
Thank you, Chair. Chair, what I'd like to do is just to, for the purposes of the record, explain the steps and efforts that were taken from the Commission's side to give effect to the ruling, and then to come to where we are now, and what I propose we do in these circumstances. So if I can begin with the ruling. The ruling is quite clear, the ruling of 29 July. In clear terms, what it says is that Mr. Karim is required to appear and to testify today, and that he may only do so if he is excused on the basis of an independent medical assessment.
He may only not do so.
He may only not appear.
Yes, you left out the not.
Thank you, Chair. So he may only not appear today on the basis of an independent medical assessment, which was to have taken place by the 12th of August. Immediately following the ruling, the evidence leaders took steps to obtain the names of suitable independent specialists who could attend to the task. We provided the name of such a specialist to Mr. Karim's representatives the day after the ruling. That's the 30th of July. On the 31st of July, we received a response from Mr. Karim's attorney saying that they had forwarded that information to the family and to the treating doctor. You'll recall, Chair and Commissioners, that the ruling required that if there is no agreement on the proposal from the evidence leader's side by the 3rd of August, that then the president or the chair of the professional association should nominate an independent specialist. So we heard nothing further from Mr. Karim's attorneys. And so we wrote again on the 3rd of August, the deadline, requesting a response by 10 a.m. on the 4th of August, especially a response as to whether Mr. Karim has consented to an independent medical evaluation, because we were concerned with putting things in motion and putting people out unnecessarily. We also indicated in that letter of the 3rd of August that if we didn't hear back from them by 10 a.m., that we would then contact the president of the association in order to set things in motion. No response was received on the 4th of August. We approached the president, who nominated a specialist. And we thank the president of that association for responding to the commission's requests with urgency and providing us everything that was required. And we regret if there was any inconvenience caused. The president provided us with the details of the independent specialist. This was communicated to Mr. Karim's attorneys on the 6th of August. It was only on 12 August that the evidence leaders received the treating doctor's report, the report that Mr. Premad has now referred the commission to. And so the report provides to us, for the first time in this process, a detailed explanation of what is said to have occurred following the ruling on the 29th of July. Whatever may have been occurring between Mr. Karim and his family and the treating doctors, none of that had been communicated to the evidence leaders while we were attempting to give effect to the ruling. The report essentially is an opinion by the same treating doctor as to why Mr. Karim could not consent to an independent medical evaluation, and it provides further material information regarding, clinical information regarding his condition. Notably, it says nothing about the outings that we referred to in the postponement application, the daily outings by Mr. Karim. There is reference to the 14 July excursion to Woolworths and to Kauai, but, and that's for the purposes of complaining that it had become public, that it had been made public.
Is the answer to that not possibly that that was dealt with in the postponement application, even by the treating doctor?
Well, it wasn't dealt with in depth by, it wasn't dealt with from the perspective of what the meaning of that is for Mr. Karim's inability to testify now. And that's what we are concerned with now, is the current condition in the light of these daily outings. I would have expected that that would have been addressed more fully, given that it was a significant aspect of the, from the evidence leader's side, the opposition to the postponement application. But that's not the main, that's not it. The problem, the difficulty we have also with the report is that it's a lengthy report that's furnished 2 days before the hearing without any opportunity for the evidence leaders to obtain a considered expert opinion upon, expert opinion of the contents of the report, right? As the Commission is aware, there is an independent specialist that the evidence leaders have consulted and would have otherwise wanted to consult on this. But the report is expressly marked strictly private and confidential, medical privilege invoked, not for dissemination, and that it is furnished strictly and only for the consideration of the chairperson, commissioners, and the evidence leaders, that places us in a difficult position because it's prepared at a level of clinical detail, and it says so. The doctor this time says the last reports were for a layperson. This report, he says, is prepared at the level of clinical detail that's appropriate for consideration by a medical professional, but the restriction that's imposed upon its dissemination makes it impossible for us to obtain, for our own purposes, any independent assessment from an expert of that report. So where we find ourselves now is in this circular process, and we keep going around the mulberry bush with respect regarding this witness. And at the time remaining for this commission, and this is the submissions I'd like to make on how we'd go forward, Chair and Commissioners, there's limited time remaining for this commission to complete its mandate. At this point, we submit it's appropriate for the commission to simply make its findings based on its assessment of the evidence that's already before the commission in the previous hearing at which Mr. Karim was present, and the evidence that's been provided, and also, for that matter, on the basis that there's certain information that has still not been furnished. The chair is now familiar with the basic information that we've requested on just financial statements. That hasn't been forthcoming in the interim since the postponement application either. So what we would submit is that the commission now just makes its findings based on the evidence that it currently has before it, without any further...
What kind of findings do you have in mind? I'm sure you are not referring to the postponement application because the ruling on that application was made on the basis of what was before the commission at the time of the hearing of that application. So what sort of findings do you have in mind?
Chair, I'm referring to any findings to be made on the basis of the evidence that was led on the 9th and 10th of March. So it's on the merits of what the issues are, whether it shows any of the conduct that we were presenting at the time that we felt fell within the terms of reference of the Commission.
I hear you.
So it's those findings. So the evidence we have is the evidence we got.
Yes.
And let's live with that, is what I'm proposing.
Yes,
But
and what is to be done about the issues that the evidence leaders considered to be still outstanding? There's nothing that can be done in that regard. Conclusions will just be drawn in whatever way regarding those outstanding issues.
Yes, the witness hasn't been able to make himself present to address any of that, and the Commission should follow the normal course as it would in any other hearing in the absence of answers to draw its conclusions.
So if the outstanding matters tell an adverse story on their own without anybody speaking to them, then the Commission may draw whatever inferences in that regard.
Indeed so, Chair. That would be the normal course in any hearing, even in a court. So that's what we propose should happen going forward, except for the following, which I'd like to add as my final submission, and which is that we do request that the Commission records the non-attendance and refers this non-attendance and the record to the NPA or the relevant authority for further consideration for potential breaches of the provisions of the Commissions Act and the regulations. Chair, and the reason for that is that the Commission, through its ruling, has given Mr. Karim a fair and objective route to establish medical unavailability. He chose not to opt for that route. the ruling is clear that the witness may only be excused on the basis of an independent report, and we don't have it. It's not a finding that's going to be made by the Commission. It's a finding that will lie elsewhere, but it needs to be referred to the relevant authority for potential violations of the Act. Those are my submissions, Chair.
Thank you, Ms. Hassim. Mr. Premier?
6 very brief comments in reply, if I may, please, Chair. The first one just relates to timing. I'm surprised to hear my learned friend complain about the fact that the 12th of August gave them insufficient time, whereas in Chair's original ruling from the 29th of July, had Mr. Karim participated in the independent medical examination, that report was always going to be delivered by the 12th of August. And so to latch onto the date...
That was not Mr. Karim's doctor's report.
Correct. Correct.
So I don't get your point.
The point is simply to say that the 12th of August was always a line in the sand that the commissioners had itself identified that the status of Mr. Karim would be known or not known, even flowing from the independent medical exam report.
I still don't get the point. You're talking about a different report, and the report in the ruling was to have been a different report. So I just don't get your point.
Correct.
At all.
All I'm saying is that, of course, the report was going to be different. That report was going to be pursuant to the independent medical exam. I'm not quibbling with that at all. But what that report would have done is it would have clarified Mr. Karim's status to participate in the commission by the 14th on the 12th in any event, because he would either be excused as a consequence of that report delivered on the 12th.
Ms. Hassim is making a different point. She's saying they were not given sufficient time to decide what to do after a different report. Not the report that was expected. A different report was given at the 11th hour. That's a different point altogether.
I'm willing to accept that, and I'll come back to that point in comment number 5, if I can, about what the true status of the cooperation with the Commission has been. But if we put aside the 12th August date for the time being, can I please give you 2 references to the medical report itself, if I may? The first one comes from paginated page 220, under the heading, "The Ruling and Attempts to Obtain Mr. Karim's Decision." And what is listed at paragraph 15.3 all the way up to paragraph 15.10 on paginated page 222 is a full account of what happened regarding the ability to produce this report any sooner. And in particular, in addition to that, I'd point the Commissioner's attention to paginated page 225 at paragraph 19.2, which talks about, and how you read this with the greatest of respect is you read those paragraphs, which is the chronology paragraphs, side by side with 19.2 on paginated page 225, which talks about a medical incident which happened on the 11th of August in the morning. So the day before the report was written and tendered to the Commission, there was a medical incident which was nonetheless reported to the Commission, which impacts and explains perhaps why this report was only given when it was given. I accept the criticism might be that it should have been sooner, or it could have been sooner, but the objective evidence in front of the Commission accounts for that entire timeline, including dealing with the difficulties in obtaining instructions. That's point number 1, Chair. Point number 2, I'm not going to deal with this in any great length because Chair asked my learned friend Ms. Hassim the correct question we submit, which is that when the outings, and I'm using that in inverted commas because they're not outings, there is a clinical explanation for that, and the Commission has the medical report in front of it. But let's use that term, even though it carries a certain connotation.
Maybe it doesn't take us anywhere, but
I think Chair has the point.
I'm interested to know what your idea of outing is when you say outings, but these are not outings. From where I'm sitting, they appear to have been outings.
Be that as it may, even if we accept, and I respectfully don't accept, but I accept what Chair posits to me, that they appear to be outing which is now in front of the Commission, explains in particular what happened after Chair's ruling on the 29th of July and what was undertaken or not undertaken in that regard. And to the extent then there are references to historical facts, that's also dealt with in this report, and those 7 or 6 other medical reports which have historically been tabled haven't been challenged in front of the Commission, and they stand as an explanation for those outings,
You see,
one way or another.
last time, and I will repeat even now, last time when you made a similar point about these reports not being challenged, I said to you, how do you expect them to be challenged when Mr. Karim is resisting, strenuously so, to be examined by somebody who can actually challenge those reports? So it's a non-starter for you to talk about a lack of challenge.
That's
Complete non-starter.
I respectfully disagree with you for 3 reasons, and this is my third comment. In the first instance, the doctor has himself made himself available on more than one occasion to the Commission.
It's not the doctor that the Commission wants to have assessed. It's not the doctor.
Be that as it may, it's a less intrusive means that's available to the Commission in circumstances where the purpose of the examination is to run a parallel process to verify those clinical opinions. That's the purpose of getting the patient into a voluntary medical examination. The point I'm making is that the doctor...
I'll listen to the rest of your rebuttals, because you say you disagree with me, and I think you said on 3 bases.
Yes.
So the first one, I do not accept at all. You may continue arguing on it, or you may proceed to number 2 and number 3.
No, I won't. It's on the record, and that's sufficient for my purposes.
Okay.
The doctor's made himself available. Nobody's chosen to do anything about that.
Nobody wanted to assess the doctor. So
No, but
may I finish?
I apologize, Chair.
That's simply not an answer to my point.
With all due respect, though, I think we're speaking cross purposes, because what Chair is saying...
We are not. I understand you perfectly, and I'm sure that you too understand me. To counter the question whether Mr. Karim is indeed unable to come to this commission, the commission has said it wants to have him assessed by an independent specialist. He has refused that should be done. That's the assessment that the commission wants to have. It's not an assessment of Mr. Karim's specialist. That's the simple point I'm making.
Yes.
And for Mr. Karim to offer us his specialist, that does not assist. In fact, that actually takes us to what courts always say, the hired gun principle. Because from where we are sitting, we do not consider Mr. Karim's doctor to be an objective expert. He is an expert that's closely associated with Mr. Karim, and who, from where we are sitting, unless we get another opinion, appears to us to be pushing Mr. Karim's story. So very close to, if not analogous to, what courts have referred to as a hired gun. In this sense, if a court wants to get an objective view, it will want to get someone who is independent, as opposed to someone who's closely associated with the person concerned. And this is exactly what we have here. A medical specialist who has been treating Mr. Karim for this lengthy period, and who on certain facts appears to have shifted the goalposts. And why do I say so? I say so on the basis of that paragraph that I referred to during the postponement application. In fact, I referred you to more than one. There are the paragraphs where he changes his story on factual issues, not issues related to Mr. Karim's condition, on factual issues. He changes his story because he said a patient can only go out of the facility, only, underline only, if I allow them to go out. But once we got the Woolworths and the Kauai visits, all of a sudden, the doctor now changes tack and says, oh no, actually, even nurses do allow patients out. So from where we are sitting, those are indications that this is a doctor who has so aligned himself with Mr. Karim that sitting, I'm not saying he's lying. All I'm saying is, sitting where we are sitting, we just cannot accept what he says. We do want to have an independent assessment, which we do not have and which we will obviously never have, because this same doctor strenuously resists that, and it is best known to him why he does so. Of course, it does explain in the reports that he has given. But from where we are sitting, we cannot just accept that. So it is on that basis that I say, in accordance with jurisprudential authority, his position is very much analogous to that of a hired gun. And it's in those instances that courts always insist on someone who is independent, someone who is objective, but as I say, we are not going to hold our breath on in that regard. We are not going to have such an independent assessment. So I say again to you, you cannot say that, you cannot respond to my point about the lack of contradiction in the manner in which you do, because that opportunity has been refused. I know I've said a lot, but respond anyhow you want to.
No, I'm indebted for the indulgence to respond. I am cautious, however, that I'm not going to take us in a circle regarding this contention, because I've understood what Chair said. I disagree with Chair's characterizations in two respects in that regard. And in fact, I think for the first time, the criticism that Chair has posited regarding the doctor has done two things with the greatest of respect. The first one is it's clarified what the actual concern is regarding the doctor's objectivity. That was the word that Chair used. And also to set out the justification as to why the independent medical exam is potentially needed because of that concern on objectivity. May I say two things in response to that, please, Chair? The first one is, I think, and I say this with all due respect, and I hope this doesn't come across as being impertinent. I think, Chair, you've actually articulated why the doctor is more necessary, not less necessary, if his objectivity is in doubt. Because if his objectivity is in doubt, which is not necessarily the same regarding the rightness or otherwise of his clinical conclusions, then it's him as the doctor offering that evidence who has to be impugned so as to demonstrate that his objectivity is justifiably in doubt, and whereafter his objectivity is justifiably in doubt, then the gateway mechanism to the medical examination is opened. So where I respectfully disagree with the Chair is I say the conflation, and I use that word respectfully, I obviously don't mean it in a personal way, but the conflation that Chair has made in positing the reason for the independent medical exam to me is an objectivity issue. But if that's an objectivity issue, an independent medical exam may come to the same conclusion that this doctor has, but that doesn't do anything in respect of his objectivity or otherwise. And what I would respectfully say, and what courts do all the time, is where an independent expert is used by one side or another as to evidential issues and legal conclusions, then you don't go and bypass that particular expert to go to the underlying individual or evidence. You impugn that expert. You impugn his objectivity, whether by demonstrating he's a liar, whether by introducing your own rebuttal expert witness, or so on. That's the ordinary mechanisms of litigation. And so the conflation that I'm respectfully contending for is...
May I just say, I'm not conflating anything. We don't have to have only one reason. The reason may one be the commission wants to be sure that there isn't a basis for not accepting what Mr. Karim's doctor says. That's one. And two, I'm then saying the doctor appears even on factual issues to have so associated with Mr. Karim's case, let me call it that is additional to the first reason as to why the commission would want to satisfy itself. So the original reason stays, it remains. So what you are addressing does not suddenly become the reason.
No.
Yes.
Thank you, Chair. Could I be cheeky?
And sorry. And also I'm not altogether sure that I agree with you with this staggered approach on how one deals with expert evidence. I don't agree with you. You may upfront just say, I want to establish whether this should not be questioned by, at the outset, having an independent assessment. So your staggered approach, I just don't agree with. Yeah, you may respond.
Chair, I still have my second reason I'm going to come to. I'll come to that in a moment. I'm just on the objectivity leg if I can. On the issue of the reason, I'm going to be a bit cheeky and say it can be any reason to doubt the objectivity. It doesn't matter what the reason is. My fundamental point, and I know Chair says he doesn't conflate anything, I'm going to step away from that word. My simple point then is to say that if whatever your reason is to doubt the objectivity of the expert put up, in the particular instance of a medical examination, you cannot leapfrog that evidence and that practitioner to go directly to the patient.
Why not?
Because that's going to be my second response to you, because then that takes us into the V-raise issue and whether or not you have the power to do that in the first place. So what I'm saying to you, Chair, in response to those three things you said about it could be any reason, he's associated himself with the case, and that's the basis for the concerns about and that you don't agree with the staggered approach that we're talking about. I'm willing to accept that, but I respectfully disagree with you, because not only does it leapfrog what we submit respectfully to you is the correct sequence having regard to what happens in the High Court, we also say that there's a V-raise challenge potentially to the extent to which you can make such an order and compel such examinations and proceedings.
There's no compulsion, and I'm not even sure that the virus issue that you say you are going to argue, and on the basis of which you are talking leapfrogging, even arises. There's no compulsion. It says, I think
it says voluntarily.
Exactly. No. So if he chooses not to go, nobody will force him.
Yes.
So the virus issue really does not arise at all. I know I've gone to your next point, which you have not argued, but because you've already mentioned it, nothing stops me from dealing with it. So this virus issue, from where I'm sitting, simply does not arise at all. So there's no leapfrogging at all.
Well, with all due respect, I think that it takes, and again, you would have received the highlighted transcript, which we say bears out our recollection of events from the last occasion, and I'm not going to revisit that. All I'm going to say is that takes us to the exact point that we debated there, which is, if it is truly voluntary, then no negative consequence can attach on the election of the voluntary choice. And that's where Chair and I think we agreed that we were ad idem in that regard, and then Chair moved on to, but what are the consequences if he chooses not to? And then are those subject to some or other bar? And I said to Chair, no, that's the ordinary consequence of how you determine evidence. So the point I'm making about the voluntariness of the proceeding and how it relates to the virus challenge is the degree to which the non-election to participate for the reasons in the medical report, which I would call gently a supervening medical impossibility, but be that as it may. If Chair is, and I think we're ad idem on this actually, if Chair is not going to attach any punitive consequence or coercive consequence to the election in the voluntary scenario.
Let me upfront tell you what I am, or rather what I think the Commission should do. The Commission is minded to refer Mr. Karim for a criminal process. What the relevant authorities do in that regard is for them to decide. Whether it's taken to the South African Police Service for them to see whether they can lay charges, or the National Prosecuting Authority for it to see whether to prosecute. That's their decision. That is what the Commission, as we are sitting here, is minded to do.
Yes.
So that will not be coercion by the Commission as
Yes.
such. It will be those functionaries who
Yes.
have the power to do whatever is within their remit
Correct.
to decide or do.
Correct.
That's what we are minded to do. So that you are not arguing in the dark.
Yes.
Let me upfront tell you what we are minded to do.
No, I'll deal with that. That's my last point, which I'll deal with about any such referral. So I'll come to that if I may. I just want to deal with this voluntary nature of the choice that was made. And I want to clarify that I was not suggesting that the voluntary choice given in paragraph 2 of the order was not a voluntary choice, and that was somehow coercive or involuntary or anything of the kind. I was simply reminding the commissioners about that voluntary characterization, because some of the language that was used about not subjecting himself to a medical examination was, to my mind at least, and if this is wrong, I accept that it's wrong, was going into the territory of adverse consequence for that. And that's why I was just reminding us about the debate we had about voluntariness.
I thought in the end, you and I agreed previously
That's the
when we
point.
debated
Yes.
that point. I said to you, I was not talking about adverse consequences that would arise purely from the fact of failing to testify.
Then we're ad idem.
We were
Yes,
even then,
and we're still ad idem now.
I think you actually
Yes.
said so. Yes,
We're
okay.
still ad idem.
All right,
That's
please.
the only
You
point
may-
I was
you may-
making.
okay, you
That's
may-
the only point I was making.
may
So,
continue then,
Thank
yeah.
you. My fourth comment on this issue about obtaining, because Ms. Hassam said something to the effect about the time consequence, only receiving it on the 12th, that there's limited time to receive their own expert rebuttal evidence, for lack of a better phrase, to obtain their own instructions regarding that and their next steps. All I'm going to say on that regard, in that regard, Chair, and not to reopen something we've moved beyond, is that's also part and parcel of the tender that was made as to why the doctor would make himself available. Because you'd remember the doctor didn't only say, obviously subject to in-camera because it's about medical information, I'll come here and opine to you. Express reference was made about cross-examining him and so on. So to the extent that there's been any prejudice caused to the commission as a result of the late receipt of that report, all of those mechanisms which were tendered previously, and in fact the doctor tenders once again in the latest medical report, is available to the Commission. And if the Commission wants to do anything with that, their own witnesses and follow up however they want to, will be in the Commission's hands in that regard. But I must place that on the record, because any suggestion that my client is just running away from accountability and not himself, through his family and medical representatives, doing whatever he can to cooperate with the Commission in the circumstances in which he finds himself, needs to be responded to, and I won't take it further than that. Those mechanisms are there, and if they're going to be used, we'll cooperate to the extent that we can.
If one were to use the analogy of civil proceedings, what normally happens, yes, what you say does happen if one side, for whatever reason, does not have an expert.
Yeah.
But what usually happens is for the opposing side to have their expert consult with the plaintiff.
Yes.
And to then prepare their
Yes.
opposing report.
Yes.
And then the two experts get called.
Yes.
So now what we have here, there's resistance to that assessment, and what, I'm the one who should now read and comment on your reaction.
Yes, indeed. My shock and horror.
Now, what's happening here is, in addition to that resistance, the one doctor offers himself to appear before this commission and to be subjected to whatever questioning. So it's rather an odd one. But as I said right at the beginning of what I'm saying now, it does happen on the odd occasion that there may be one expert, but the norm is to have two opposing experts.
Yes.
Both experts having examined
Yes.
the patient, done their own assessments, prepared individual reports on that patient. Yeah. Now let's hear you on that reaction.
I'm not sure I agree on where you ended, Chair, which is to say that both experts examine the patient and then give the differing rebuttal evidence. And the reason I say that is, obviously we're not in Rule 36 territory about the assessment of damage from medical injury or whatever the case might be. And also because it's a voluntary examination and it can't be compelled, that's why I disagree with the characterization in the way of this expert rebuttal process.
I'm not in the realm of the virus issue.
Agreed.
I'm
Neither
not
am I.
there at all.
Agreed. Neither am
I'm just at the level of how evidence of this nature is ordinarily dealt with, how it plays itself out in a court environment. That's all I'm debating.
We're in the same place.
Yeah,
I'm not in the
yes.
V-raise.
So the voluntariness,
Yes,
compulsion, and so on does not arise in that context.
Agreed. I was just saying that those are the important context issues which need
I've not forgotten
to be
them.
considered.
I've not forgotten
I'm
them.
indebted. So the point that I would make regarding that process that Chair posits to me about rebuttal witnesses and contrasting experts, and Chair says is in the ordinary course, that's what I was saying a bit earlier about less intrusive means about the available to the Commission. If the doctor's evidence, which Mr. Karim's doctor's evidence, which relies on his objectivity, is in dispute. And that's the basis through which it can be impugned as a less intrusive means without taking us into a V-raise problem about is this voluntary examination voluntary or not voluntary. So I would respectfully say that what Chair has posited to me is the exact thing that the doctor has been tendering, and I think, in fact, in correspondence, Mr. Karim's own attorney said, let's do it this way so that you can get the degree of satisfaction that you require. Now, I understand, Chair, to say that, that might be how it's ordinarily done in the High Court and maybe it's different in the Commission or whatever. All I'm saying is that's a process that's available, and if my learned friend contends that there's prejudice suffered as a result of the lateness of the report, whatever unfolds as a result now that they have the report in their possession will unfold, and we'll deal with it as we need to deal with it. But the fact that the mechanism is available, which we on behalf of Mr. Karim proactively offered, and Chair himself now recognizes as a possible mechanism. I'm not saying Chair says it's right or correct or good or whatever. I'm just saying it's in the realm of possibility.
Which mechanism? Are you talking about the doctor?
The rebuttal witness mechanism that Chair started talking about. I'm saying that the fact that that mechanism exists in the possibility of options in next steps as a less intrusive means is as far as I'll take it. The fact that there are ways to obtain the Commission's own assessment about objectivity or
But
otherwise
that assessment
without the medical examination.
No. I was talking pursuant to a medical
Yes,
examination.
but you remember that's-
And that's what Mr. Karim, through his doctor, is resisting. So
Yes.
I don't get you.
No,
Yeah.
remember I said that was a contextual issue, that the voluntary exam is voluntary, and then Chair responded and said, but we're not there because that's a virus issue and we're not talking about
There
that.
can't be a rebuttal witness in the sense I was talking about if there has not been an assessment by that doctor.
And that's where I said I respectfully disagreed with that. Remember, that's the first thing I said, is I disagreed with that characterization at the beginning.
I just wanted to make sure, that because it seems you misunderstood me.
I didn't misunderstand.
I was talking rebuttal after an assessment by that rebutting doctor.
And I immediately responded and said, I'm not sure I agree with you in that regard.
Can you move on to your next
No,
point?
that's
then,
fine.
Please?
I was just setting out then the basis for my disagreement with you, Chair, respectfully, about how that mechanism is going to work. I don't have to take it further.
We can't force him, we agreed, and
Exactly,
which is why I'm talking
exactly.
about the criminal process that the Commission is minded
Exactly
to.
the point, Chair.
Yes.
Exactly the point, Chair. So that is available. May I just then speak to what the Commission says is the way forward? Chair, you'll remember that in its letter, I'm going to read from page 119 of the correspondence bundle, but as far back as the 24th of June 2026, this is the Commission's letter to my attorneys. At paragraph 12 is exactly what the Commission says today is the way forward, obviating the need for a medical exam.
Evidence leaders, Mr.
Evidence
President,
leader,
don't confuse.
I apologize.
Don't confuse what the evidence leaders say with what the Commission.
I apologize. The evidence leaders, and I don't want it to sound like I'm
They
now
say
personalizing
in the
Ms. Hassan.
circumstances, the evidence leaders will proceed as follows.
Yes, so, and that was, you'll remember that was on the 24th of June, and then I think we were in front of you. Was it the 1st of July? And then there was an exchange of correspondence, and this medical exam issue arose after this letter. But in response to that particular letter at paragraph 12, came our letter, which starts at page 121, which says, yes, if that's what you want to do, that's what you must do. And so insofar as Ms. Hassan says today, the evidence leader says today, that this is the position of the Commission, and we'll...
Of the evidence
evidence leaders, I apologize. Ms. Hassan says that this is the position of the evidence leaders. We understood that to always be the case from that page previously, and we've never taken objection to that, which is why, Chair, you'll remember in that debate that we had, I think, that the transcript refers to, when you and I were discussing the adverse findings that were to be made, my response to you was that, yes, that's the ordinary way in which evidence will be dealt with, and if it's unanswered, you'll draw the appropriate inference, you'll draw the appropriate credibility finding, and that's the risk that my client was always subjected to, and that's the consequence he must face. So if that's the Commission's attitude today, consistent with what they previously said on the 24th of June, in that debate with you, Chair, you'd remember I said I can't commit my client to a position, but I explicitly said to you I could not fault that that's the end point we'd come to. So to the extent that's the evidence leader's, Commissioner Kamalo, to the extent that's the evidence leader's position in front of you today, I accept that position. In fact, and not to be flippant about it, we were already here a month and a half ago, and only as a result of the Commission's extension and the possibility of a medical exam did all of these issues arise all over again. So in fact, we're now going back to the position that we were in late June, and with all due respect, the Commission, but also sometimes the evidence leaders complain that the Commission is running out of time and there's no guarantee of an extension. So we're back to where we were on the 24th of June. The Commission and or evidence leaders will do what they do and we'll deal with the consequences. Lastly, Chair, on the issue of the possible recommendation of criminal sanction, whilst you've got that the letter I referred you to starting at 121 in front of you, it's just a few pages on from the Commission's letter at paragraph 12 that we were dealing with. If you could please go to paginated page
124?
124, yes indeed. That's the request.
Again, Commissioner Kumalo.
Thank you, Chair. I'm indebted. Particularly paragraph 11. If such a recommendation is going to be made, then on that specific question about whether criminal charges should be recommended or not recommended, all I'll say is that our client, as far back as the 24th of June, asked that if such a referral was going or recommendation was going to be made, that he be given the chance to address specifically that referral decision consistent with authorities like Dupria and so on, and also because that's an Audi issue, we say respectfully, and particularly to place in doubt the question of willfulness and whether or not such criminal charge is competent and viable as against my client. However,
sorry,
oh,
but
apologize.
aren't those issues, that is the issues of willfulness and so on, issues that should actually arise before the relevant criminal authorities, if that referral does not get killed at the level of SAPS or
Yes.
at the level of the NPA, they may then be dealt with by the criminal court. So I'm not sure I get your point.
What I was going to say, and then rightfully I showed deference to the chair, is that on that particular point about Audi in front of you before the recommendation, I was going to say that's not the hill I'm going to die on, because it might be correct that you can make the recommendation being recommendatory in nature without ticking the box of direct external legal effect as well as adverse consequence, that you even owe us the right of Audi at that stage, because the correct decision-making functionary is where we'd have the ability to make those representations anyway. So what I was going to say to Chair is that the request is in front of you. You may choose to say no, which is fine. I'm just saying that the request is there. That's all I have to
We are
say.
all here now. Make whatever submissions you have in mind in this regard, so that we are done. It's done and over with.
Thank you, Chair. May I just make 3 submissions in this regard then? Number one, the test would be willfulness for any such breach or non-compliance. We say that the threshold is not met, having regard to the medical evidence that is in front of you, and which is unchallenged. And I know that that's sensitive territory, so I tread lightly. That's the first point. The second point is that the point about that evidence being unchallenged, so to speak, and where non-compliance is as a result of medical advice as a valid and legitimate excuse, is actually something recognized by the foreign authorities that my learned friend Ms. Hassan handed up at the last hearing. you'll remember I was going to do an audit of those authorities, and then Chair intervened and said, no, maybe we can leave those authorities, and we did, and I never went on to those authorities. But can I just give you the single reference to the one authority, please, that is in my learned friend's bundle, and I just want to point it out because I say that that's the second basis upon which we're entitled to utilize that as a valid excuse for non-participation. And if Chair will just bear with me, I now need to find my own papers. Yes, it's the authority of Wandsworth. The full citation is Tainaz versus Wandsworth, square bracket 2002. It's the England and Wales, I think it might be Court of Appeal, EWCA. No, it's the Administrative Court, I apologize. EWCA Civil Division 1040. At the bundle that was given to you by my learned friends, you'll please look at paragraph 21, where the conclusion reached by the court in that regard is that where a litigant was unable to attend through no fault of his own must usually be accommodated, however inconvenient, and then goes on to say it would be absurd to criticize a litigant for not attending to give evidence on his condition when the doctor has advised him that on medical grounds he should not attend. That's at paragraph 25 of that same authority, and in the paginated bundle you'll find it between paginated pages 31 and 33 of that bundle. So that's the second reason, Chair, that there's authority to say that there is a valid exculpatory reason which has been given. And the third one, Chair, is to say that, and I don't want to rehearse this argument, is that rather than recommendation which is a and I use this word guardedly, but which is potentially punitive to obtain a particular outcome, is he well or is he not well, as on the back of not complying or not attending, there are less intrusive means available, and that a criminal recommendation in the circumstances is the most extreme option available, and that the Commission can still, and if the Commission does that, and I hope I'm using Commission in the right sense now, Commissioner Khumalo, if the Commission does that, it almost brings that line of inquiry to an end because it passes it over to a different functionary. But that if the Commission and the evidence leaders was interested in continuing this line of inquiry to establish what is or is not the case, then less intrusive means are available. So at a broad level, those would be the tenor of our submission, subject to specifics, but I appreciate the Chair's affording me an opportunity to highlight that all the same.
Two related issues. One is laying a charge a recommendation in the sense in which you've referred to, and two is laying a criminal charge, something that would implicate the Audi rights at all.
Well,
This is just laying a criminal charge. And ordinarily, the Audi rights would be implicated in a situation, or would arise in a situation where a decision is taken. I know you'll say, well, laying a criminal charge is preceded by a decision to lay the criminal charge. I'm happy that you are shaking your head and that you are not going to say that. I'm happy to hear that. So one is laying a criminal charge, a recommendation in the sense in which you use that word, and two is laying a charge, or does laying a charge implicate Audi rights at all?
Why I shake my head is because I think it depends on the underlying conduct. So if there's a recommendation for the preferment of charges, so in other words, you, Chair, in your capacity as Chair, write to the SAPS, whoever the relevant police station would be, and say, we recommend that you open a case for an offence of the Commissions Act, then I would say that is where the territory is of Audi because of the
I don't see why the letter would say a recommendation is being made. Someone would just go to a charge office or write to the police and say, a charge of ABCD is being laid. So that's laying a charge. It's
Yes.
not recommending that
No,
a charge.
yes.
And then it's for subs to investigate or look at the information given and then saying, because of the authorities that Mr. Premhid referred to, there is no case whatsoever here, and therefore they refuse
Yes.
they do not even take that docket to the NPA.
NPA. No, that's why I'm saying it depends on the underlying conduct. If you are the complainant going to and I say you, I mean obviously ex officio in your capacity as the chair, or the secretary perhaps, because I understand that the secretary is the hand through which a lot of the operations of the commission unfold. So I'm going to refer to the secretary. If the secretary is herself, in her ex officio capacity, the complainant at the police station, then that's why I was saying it depends on the form of the conduct. Then I don't think I could have an Audi objection, because that's as good as, and now I'm going to abuse Ms. Madlangwa's name next to me, that's as good as if I went to the police station and laid a charge against Ms. Madlangwa for intimidation, which is probably coming very soon. She's a very good junior. But I don't owe her a right of Audi. I accept that. That's why I was saying, however, if the secretary is going to write to the SAPS to say, I am recommending that you SAPS charge Ms. Madlangwa with intimidation, and that flows from an ex officio capacity.
Let me right away say, if what I said the commission is minded to do does eventuate, it will not take the form of a recommendation. The commission will just lay a charge.
Yes,
so I think we should just step off this idea of a recommendation.
No, correct.
And let's move on.
Yes,
on the
because
basis that will not eventuate.
Yes, because that also takes me to my original point, which was to say this might not even be the hill for me to die on, because it might be appropriate that any such Audi right is not given effect to in front of you, per se, but then in front of either the SAPS or the DPP or whomever, as you ordinarily have the right to make representations to the DPP before any such case commences. So I don't think we are disagreeing with each other. I was only responding to the question Chair posited to me, which was what's the difference and what are the consequences between a recommendation per se and the laying of a charge, and I was trying to engage with
how the Audi rights get
Yes.
implicated.
But because Chair has now said to me that if it is to eventuate, it's not going to take the form of a recommendation, the Audi issue is irrelevant with all due respect, because I think we've come to a consensus that if there's an Audi in the context of the laying of the charge, that must happen elsewhere, not in front of you.
But I'm sure we are agreed that you've made all your submissions.
Yes,
in this
absolutely.
regard, so that you don't say, but Chair, you said, are Audi rights implicated at all? And that is you.
No.
And I said, not if it's not a recommendation.
Correct.
You made your submissions on the Audi points and whatever other rights in this regard, and you even came to the point that we are done with our submissions.
In fact,
I just want to make sure
in fact, Chair, you've been so generous to me. Before any decision to recommend or lay a charge has been made, you've invited me to make those submissions in the first place. So,
Yes.
so I am very, and I did, and I'm very indebted to you for that opportunity, and indeed to respond to what my learned friend said, considering that I was very short in opening. And I'm indebted for that. In fact, we've taken far more time than I would have hoped for, and I apologize for that if that's my doing. So, but I'm indebted to you, Chair. May I just take an instruction?
And Commissioner Baloyi has a question.
Oh, I apologize.
Yes. No problem.
Thank you. Mr. Premier, is it not simply this? We are sitting here where Mr. Karim has not appeared, contrary to a ruling that he must appear today. And that ruling had behind it that he would be excused if we get an independent medical report that says he's not good to testify. We're sitting in a place where we don't have that medical report, and therefore there's no basis for us to say he is properly excused not to be here. Aren't we sitting with, there is no satisfactory explanation, therefore, for his non-appearance? And then, because our rules do deal with such matters, if a witness is required to appear and they do not provide a satisfactory explanation, certain consequences would follow. Isn't it simply that we're sitting where we do not have a satisfactory explanation because of the issues that you have been ventilating with the chair, but the bottom line of it is that which was prescribed as a basis to excuse him has not been complied with. Therefore, we do not have a satisfactory explanation, and we must deal with it in accordance with our rules. Is it not that simple, really?
Well, I think the danger in characterizing it as being that simple, Commissioner Baloyi, with all due respect, is that then elevates the modality, which is voluntary, but let's leave that to one side, the voluntary of the examination and the excuse to being a prescriptive basis to exclude any otherwise valid excuse. So on your narrow reading, if I understand correctly, Commissioner Baloyi, I can't disagree with you. And the reason I can't disagree with you is because, of course, in terms of what the order specified, non-compliance has arisen. But what I'm saying is I don't know that that would be, and I'm choosing my words carefully, I would question the competency of such a directive in circumstances where it's applied prescriptively in that way, and where non-compliance is potentially dealt with punitively because it's a strict non-compliance with the mechanism in the order, to the ignorance of evidence that relates directly to the operation of that mechanism. So I think what I'm trying to say, Commissioner Baloyi, is on your narrow, and I'm going to use the word stricter reading of the order, then yes, there might be grounds for non-compliance and needing to deal with it. But because of the evidence that is nonetheless in front of you, I would say it's not that simple. Because if the downstream consequences is then lay a charge for non-compliance, whoever has to examine the charge or make a determination of the charge has to look at mens rea and willfulness. And in light of the fact that the evidence is here already to say that there isn't any of that at play, that's why I'm struggling with the narrow reading in the way in which Commissioner Baloyi puts it to me. But I accept what you say in that narrow reading, subject to my caveat.
Well, we're not deciding, the Commission is not deciding mens rea.
Yes,
and
indeed.
we're never in a position to do that.
Indeed.
So leave that out of the equation. All I'm saying is, we have his doctor's report. You've had the concerns of the Commission about this doctor's report. There was a ruling to try and resolve the issue. That has not materialized. We sit at a place where he's not here. The Commission is not prepared to accept your the doctor's report. You've had the engagement with the chair for reasons that have been given. We end at, well, we don't have an explanation, a satisfactory explanation for his absence. Someone else will determine whether he did have a reasonable, a satisfactory explanation for not appearing. And that's a different process from ours. What we do in terms of rules is to say, on the material before us, he hasn't provided a satisfactory explanation for his absence. And let somebody else evaluate whether that constitutes a criminal offense or not.
Now, I think you and I are ad idem on the mens rea and the willfulness point, but when you are sitting, you on bank as the commissioners, are sitting qua commission and are applying your mind as to, do we lay the charge for the strict non-compliance of the order as directed? All I'm saying is that one of the factors you'll have to take into consideration as to whether or not to lay the charge is that there is evidence in front of you that suggests that a charge may be inappropriate for the reasons contained in the medical report. If you, qua commission, choose as the decision maker to ignore that or to give it less weight or to proceed and actually say, well, this is not the form of the report, Chair, this is the debate we were having earlier, this is not the form of the report that I wanted, and therefore only because of the form of the report, I'm going to close my eyes to it and I'm only going to look at strict non-compliance. You're of course entitled to do that, but I would say that that's where my concern and challenge comes about the rationality of such a decision or determination in the circumstances because of the available evidence in front of you. It's that DA versus President Simelane type of scenario that I'm postulating.
The other way of treating your doctor's report and all the evidence, by the way, not just the doctor's report, everything that has been placed before us about his non-appearance over time. Another way of treating it is to say, we've looked at all of that.
Indeed.
We are not satisfied that it provides a satisfactory explanation for his appearance. So it's not simply we closed our eyes as if those are the only things we could do. Is to look at all the material and say, on all of this, we are not satisfied that there is a satisfactory explanation for his absence.
Yes.
And on that basis, we refer.
Yes, well, I think, Commissioner Baloyi, if that's what the Commission does, though, because then all the evidence is being considered in the basket of factors, shall we say, before the charge is laid or not laid, then that's procedural rationality met. It means that you follow the correct evidential consideration decision-making process. And I don't disagree with that. A question of substantive rationality.
Trust us to do that.
Yes, no, I've never not trusted you to do that at all. All I'm saying is that procedural rationality might then be met. There could still be the question of substantive rationality, but I understand we're not debating that today or in front of you. All I'm agreeing with you on, I hope, is to say that, yes, there is the strict way of interpreting it, but now, as Commissioner Baloyi says to me, trust us that we'll consider everything. Well, that's the safeguard procedural rationality that all I could ask for, subject to any other review grounds that may arise, so to speak. Thank you, Commissioner Baloyi.
Do you want to? Thank you, Mr. Premier.
Thank you, Chair.
Ms. Hassan?
Chair, I'm ordinarily not entitled to have
all right. Thank you.
a speak, but may I say one thing in response
subject to Mr. Premier then having the last word. Yes, let's hear you.
Actually, Chair, it's in response to...
But actually...
I'm responding to submissions that he made, not to a reply.
Yeah, okay.
And it's the Audi. And I was glad to hear that Mr. Premier was finding a way to walk down the hill. But then as he went on, I thought he started to climb up that hill again that he said he didn't want to die on. And I just want to say one thing in respect of that. I mean, it's tempting to go to other things, but it is in relation to the laying of the charge. This is, in my view, and I want to urge the Commission to do so, because the reason for doing so, and let me firstly say, it's not a decision by the Commission. It is the laying of a complaint. And even if that complaint were framed as to the SAPS, we recommend that you charge this person for the following. What will the SAPS do with your recommendation with respect? It's not a binding recommendation. The SAPS will say to you, thank you very much for your view. We will do our job and we will take it from here. So it is in the hands of the relevant authority to do with that whatever it wishes to do with that. And that must play out. That's the first thing I want to say. The second thing I'd like to say is that it's important that the Commission does so. Because not only does the Commission have the power to regulate its own processes, it has a duty to protect its processes. And it's important for the protection of this Commission's processes that takes place. The context in which this particular, what we call a breach of the Commissions Act has occurred is the context that I can't go into detail on, but it is why the postponement application became so substantive and why the medical expert report was required, was why it is necessary, important, and of value in this particular context for the patient himself to be examined. So the constant sort of tender for us to talk to the treating doctor doesn't help. So that's the context in which we come across, we find ourselves here. And my submission is not only would it not be a decision that now is subject to some further audi, because it's a complaint, it will follow its course. The Commission is not making any decision regarding intention, willfulness, etc. The second thing is that, in my view, and my submission to the Commission is that I urge you to do so because it's necessary to protect our processes. Thank you, Chair.
Thank you, thank you. I doubt that you would want to say anything to that.
I'm covered.
Thank you very much. As I indicated, at least then I said the Commission was minded to. Let me outright say the Commission is going to set the criminal process in motion. The Commission will direct the relevant functionary, and as you anticipated it, Mr. Premhid, that functionary will be Dr. Vuguza sitting across there, who is the Commission Secretary, and for her to lay a criminal charge, not to make a recommendation, to lay a criminal charge against Mr. Karim. If the Commission were not to do that, it would itself not be taking its processes seriously. This is something that the Commission just has to do. Otherwise, witnesses will choose to come or not to come testify before it willy-nilly. And we cannot and we will not have that. So the Commission will lay criminal charges against Mr. Karim. Whether he has defenses to that, that's something for him to raise in that criminal process. Thank you. I will not even say that this is what the sort of decision that one usually has in mind in the context of decisions that are taken and which are reviewable. But of course, I can never stop Mr. Karim taking us on review on this, but I would be very surprised if he were to do that. I'm just announcing what the Commission is minded to do. I have a note. I will do a trump on my colleagues. Both of them have sent me notes. Oh, two issues. One is that's the end of the road insofar as us having Mr. Karim before us. That's it. Then what's happening next?
Chair, Ms. Ramsamy is ready to continue with her evidence.
What's the time now?
10.
Let's yes, we are about 20 past. Mr. Premier, you are excused, but we are taking the adjournment now anyway.
Thank you, Chair.
Ms. Karim, you two are excused.
Passive.
I'm very sorry. You must object, yes. You two are excused, Ms. Hassim. So we'll take the adjournment now and resume at 20 past 11. Let's adjourn.
Thank you.
Thank you.
Good morning again. It's 11:20. We are ready to resume. Please make sure for all members in the audience that your cell phones are off. Thank you.
Thank you,
Yes,
Chair.
Ms. Sigels Ngube. Good morning, Ms. Ramsamy.
Morning, Chair. Morning, Commissioners.
Good morning, Mr. Ramatsekisa.
Good morning, Chair and the Commissioners.
Thank you.
Chair, we're continuing with Ms. Ramsami's evidence. If memory serves me, when we left off, we were still on page 18 of her statement, supplementary statement, and she was dealing with the aspect of a meeting where reference was made to General Matlow on the 27th of May, but in her statement, she was still busy with the authorization of the Medicare 24 investigation. Before we continue with that, Chair, there's a matter that Ms. Ramsamy, that I would like to bring to the Commissioner's attention, related to the issue about the IGI report that Ms. Ramsamy testified about, that she said in a meeting on 1 September 2025, Mr. Perumal had told them that that report was flown to the Eastern Cape by the minister. That's how I recall her evidence, and I looked at the transcript. That is how she said it. She since listened, she recorded the meeting. It's a lengthy meeting, but that aspect, we would like to play that audio, because Chair will recall her evidence is obviously hearsay that as to what happened, but Mr. Perumal, on the recording, it's Mr. Perumal indicating how the report got into his possession, and we would like to play that recording, and then she will just clarify her recollection of and what her evidence was regarding that. Yes. There's two recordings that will be played. The one is just in respect of Mr. Perumal. That audio is fine. We think you'll be able to hear it without the headsets. There may be another recording that we play. It will depend on how the evidence goes. And for that one, you may need headsets, because it's a conversation where one person is very audible and the other person is not, Chair.
And do we have the headsets for council?
We don't need the headsets now, Chair.
No.
Oh, should we?
When we get to that point. Are there any in front of you, Mr. Ramatsekis? None.
None yet.
If we do play the recording, Chair, we'll make arrangements, yes.
No, it's fine.
I'm going to give you all this now because I've informed the ID, right? We all decided on the matter.
Yeah.
So there was a gentleman that was flown in secretly over the weekend from the minister's office to bring a document to me. I didn't know what the document was going to be.
Okay.
I received the document, I've informed the ID, and I'm just going to read just because of this. Because what can we agree that Brian and I stopped working on all the pointers for you on the Lushaba housebreaking and concentrate more on the Mokwele issue.
Yeah.
Right? I'm going to read now. So what it is that I received, it is the report which the ID asked me to keep.
Can you please pause?
Do you
Do
want to
these
try
improve the sound?
Can you try the earphones, Chair?
And,
In the meantime, on this one, we can follow.
oh, okay.
Yeah, maybe the next one, that's when we can. But this one we can follow.
Can we please start from?
Interrupting.
No, it's fine, it's fine.
I'm going to give you all this now because I've informed the ID, right? We all decided on the matter.
Yeah.
So there was a gentleman that was flown in secretly over the weekend from the minister's office to bring a document to me. I didn't know what the document was going to be.
Okay.
I received the document, I've informed the ID, and I'm just going to read just because of this, because what can we agree that Brian and I stopped working on you know, all the pointers for you on the Lushaba housebreaking and concentrate more on the Mokwele issue.
Yeah.
Right? So I'm going to read now. So what it is that I received, it is the report which the ID asked me to keep just with me for now until I meet with her, but I'm going to let you in on what they say about Mokwele's appointment. So the report comprises of various parts of our criminal investigations here, the buying of the buildings, Kumalo's appointment, Mokwele's appointment, and others. So I'm just going to quickly read to you what they say about her appointment, the Inspector General of Intelligence. Because I think what the ID needs to do, Advocate Peter, is to find a way, because there's good synergy between the Inspector General of Intelligence and the ID now, for them to be convinced to get somebody from the IGI to give an affidavit in support of this endeavor, you know? So they say the following, they say investigation methodology. Several documents relating to this appointment were produced for the purposes of analyzing the process of recruitment followed by the management of CI.
Thank you, Chair. Then it goes into the detail of the report, which we're not going to deal with, but the clarification from Ms. Ramsamy is that Mr. Perumal says that the report was flown in from the office of the minister, and her evidence was that it was the minister. So she wanted to clarify that Mr. Perumal in that audio says the office of the minister, whereas her evidence had said the minister himself. So that's the clarification on that. And the reason why we played it a bit further is so that you could hear that him identifying it as the IGI report, and that it is into the investigation, crime intelligence investigations, and the appointments of General Kumalo and Madondo, etc. So that's the recording on that. And then I would like to ask Ms. Ramsamy one or two questions from that recording. Ms. Ramsamy, Mr. Perumal...
So just a minute. Is Ms. Ramsamy going to identify the voices?
That's what I was going
us?
to ask her,
All right,
yes.
thank you.
To identify the voice of the gentleman that is speaking about the report being flown by the Minister's office to Eastern Cape.
Oh, perhaps let me say this. There's the louder voice and then there's a softer voice.
The louder voice is Advocate Surunya, and the softer voice that is speaking about the IGI report is Mr. Perumal.
And the setting was that it was the 1 September 2025 meeting that was called by the ID, Advocate Johnson, to, as you say, convince Mr. Serunye about the merits of the Operation Diversion matters after his email that he had sent in August, or one of 3 emails that he had sent, where he questioned the merits of the cases.
Correct.
Okay. And it is during the course of that meeting that Mr. Perumal then brings up this issue about having been given this report.
Yes, it is.
And ways in which they were going to attempt to get the report into part of your investigation in a lawful way, to do an affidavit from the IG's office.
Correct. That is.
And then he says something about the ID and the IGI's office now have a good relationship, or something to that effect, on good terms now. Do you know why he was referring to as on good terms now? And this would have been September 2025.
My understanding of that statement was that Advocate J. Govender had retired from the IGI office. And Advocate Govender is a stickler to the rules. She does not bypass the rules, neither does she hold back on her words. So my understanding from that is that because the person that was providing the legal advice to the IGI to not break procedure and what is legislated had gone on early retirement.
And now they had a better relationship, so now you could get the report, when previously, when I think you had even reported to the ID that you had a fruitless meeting with the IGI with Governor in
Correct.
January.
Yes, correct.
So now, with Governor being gone, there would now be a better relationship between the ID and the IGI. Okay. And then if I understand it, Mr. Perumal, it was a Teams meeting and Mr. Perumal was in the Eastern Cape at the time.
Correct. Mr. Perumal was in the Eastern Cape and Mr. Padiachi had logged on from KwaZulu-Natal. It was myself, Advocate Schlatzwayo and Advocate Sarunya that was sitting in the boardroom. We were using my laptop.
And initially the Advocate Johnson was also in the meeting.
Advocate Johnson called for the meeting. She had spoken extensively, as I had testified, about how Advocate Sarunya needs to understand what these cases are and that Mr. Perumal and Mr. Padiachi were going to explain it to the prosecutors, and that she had said that it is state capture. This investigation falls under the mandate because it is state capture.
Okay. Then can we, unless there's any questions flowing from that, we can go back to your statement. Page 18 of your supplementary statement.
Paragraph 38.
I think let's start from 37. From the file was encrypted. That was the IGI report, which was being used as a basis for the Section 28(1) authorization. So you can start from there after Advocate Johnson gave me the password.
It's not the IGI report that we refer to here. It's
No, the preliminary report, my apologies, yes.
The file name of the report had a date of 30 January 2025, but I do not know when it was given to IDAC by General Matlo. The file was encrypted and Advocate Shabalala could not remember the password. I responded to Advocate Johnson that I could not access the report because of the encryption. Thereafter, Advocate Johnson gave me the password. It is clear from the email that Advocate Johnson wanted to authorize the report by Friday, 16 May 2025. I did not understand the urgency. If there was a preliminary audit report dealing with the matter, I did not understand why Advocate Johnson needed to urgently authorize the investigation and even bypass the Section 2813 process. I can only speculate that General Matlo must have informed Advocate Johnson that General Masemola had intended to cancel the Medicare 24 contract and that he would do so soon, which may undermine any allegations that he failed to act. But this is only speculation.
And you say that now, but that wasn't what you suspected at the time. You didn't know that that was or you didn't have that suspicion at the time.
No, it's only after hearing all the evidence.
Okay.
From where you started reading, you say to authorize the report by Friday. I take it you mean the investigation. Where you started?
Yes.
Yes.
Okay.
Yes, thank you, Commissioner.
And if we can just go to that email again, in fact, Advocate Johnson wanted it finalized by the Thursday, so file 10285. File 10285. And it's the email at the bottom of the page. Okay. What I want to highlight is, again, the date of the email, which is the 13th of May. And then the second paragraph where Advocate Johnson says, General Matlo contacted me and I want to authorize by Thursday. And just above that, in fact, the sentence just above that, I need you to look at it urgently and then submit. General Matlow contacted me and I want to authorize by Thursday. Now, we have heard evidence at the Commission that the Medicare 24 contract was in fact cancelled on the 13th of May 2025. You were not aware of that at the time?
No, I was not.
Okay. And so you wouldn't have been aware that that could have been a motivating factor for the urgency in trying to authorize the 28-1?
No, I would not have known because even the subject says SAPS Tembisa Hospital tender.
And at that stage, Medicare 24 wasn't yet, no, well, it would have appeared on your 28-1, but when she sends this email to you at the time, you haven't seen any documents yet.
No, I had not. So I was not aware that it was in fact the 360.
Okay, then we can go back to your statement, paragraph 38.
I inquired as to how the allegations in the draft Section 28.1 came about, and where did Advocate Shabalala find the suspects, etc. Advocate Johnson indicated that I should speak to Mr. Perumal. When I asked Mr. Perumal, he indicated that he did not know where Advocate Shabalala got the details. Be that as it may, I perused the draft 28.1 application, which was quite detailed. I did not make any changes to the documents and sent to Advocate Johnson. She authorized the Section 28 investigation on the 16th of May 2025. Prior to 16 May 2025, there was no authorized investigation by IDAC into the Medicare 24. Yet Mr. Perumal, Beluchin, and Padiachi were already investigating the matter. If I may just add here.
That at paragraph 38?
Yes. When I say I didn't make any changes, I didn't make any changes to the averments that Advocate Shabalala had made or the list of the suspects. I did, however, follow instructions of Advocate Johnson and amend the designated persons to remove 3 advocates and add Mr. Advocate Manilal, Advocate Shlaswayo, and myself.
And do you record who those advocates were? Would Advocate Shabalala have been one of them?
It was Advocate Shabalala, it was Advocate Rashakala, and Advocate Paul Lowe.
Okay, and that was on Advocate Johnson's instruction?
Yes, it is in the first email.
Okay.
So Advocate Johnson had formally announced that she was changing the team. She did not just ask you to effect the change. She announced formally, and you then...
Chair, it's in the email where Advocate Johnson says,
okay.
Remove Paul, Tilas, etc.
Okay.
Yes, that is in that same email 285.
Okay.
Kindly remove Tillis, Paul, etc. from the designations.
Right, okay.
Add Santos as the advocate, as he will oversee when I am unable to attend to things. So when she says I'm unable to attend to things, it was the intention that Advocate Johnson would be in charge as the prosecutor.
Correct. She would be the supervisor of the matter.
Okay.
When did it become a Medicare 24? Because on this email, it's still being referred to as SAPS Tembisa Hospital.
Correct.
When did it formally become a Medicare 24 investigation?
So the formalization of the name itself only took place on the meeting of the 27th of May.
But that wasn't the name Medicare, that was an operation, something else, which you'll get to.
Yes, it was called a different operation, like diversion was.
Okay, but you don't know when it became Medicare 24 itself, because you were referring to it as an operation internally.
Correct.
Okay, and prior to the authorization, it was the SAPS tender, Tembisa contract, and then when she officially, Advocate Johnson officially named it, that is the name that you continued using.
Correct, yes.
Okay. 28.1 You're dealing with investigations that were undertaken prior to the authorization.
Mr. Perumal received the 30 January 2025 preliminary report from General Matlow before the Section 28(1) authorization. Advocate Johnson was communicating with General Matlow about the matter before the the Section 28(1) was authorized, but more importantly, before there was a Section 27 referral affidavit. It may be that Section 28 entitles Advocate Johnson to conduct the investigation with or without a Section 27 referral. But Advocate Johnson testified before the ad hoc committee that the investigation emanated from a Section 27 referral affidavit with supporting documents, which was referred to IDAC on the 16th of February 2025. I have not seen such a referral, and as far as I am aware, Advocate Johnson has not produced that referral before the ad hoc and this commission. The investigation must still be authorized, even if it does not emanate from a Section 27 referral. The investigation was only authorized, if one can even call it that, on the 16th of May 2025.
Continue.
The Section 27 referral affidavit relied on by Advocate Johnson during her evidence before the Commission is an affidavit by General Matlow commissioned in June 2025, after the Section 28(1) authorization.
And that is the document that we looked at the last time on page 2985 of the bundle.
Correct.
We won't go there again. Continue.
Thank you. As stated above, I have seen the affidavit of Lieutenant Colonel Khumalo regarding Mr. Perumal's request for the data on Mr. Matlala's devices on the 30th of May 2025. I can confirm that around that time of the irregular Section 28(1) authorization, May 2025, there was a lot of hubbub about the need to get Mr. Matlala's devices as soon as possible. Initially, Mr. Perumal, Belochin, and Advocate Johnson wanted to collect the devices from the PKTT, and I indicated that you cannot go and collect someone else's exhibits. You have to go and serve a subpoena on Mr. Matlala and subpoena on the current possessor, being the PKTT, or whichever SAPS unit had the devices, and then go with a service provider or a person who is in the IT, is an IT expert that is accepted in terms of the Cybercrimes Act, and mirror image those devices. This seems to be what was then ultimately done on the 30th of May 2025. I am still unclear as to what Section 28(1) was used to gain access to the devices because there is now a backdated 30 May 2025 authorization in respect of the Mokwela matter and an irregular authorization in respect of the Medicare matter dated 16 May 2025. At this stage, I was exasperated and fed up with the whole situation. It was just shortly after this that I engaged the DPCI in late June 2025. There was once again no supervision on this matter at DDPP level. Everything was going through Advocate Johnson in consultation with Mr. Perumal. Even though there was a DPP Advocate Manilal who had been briefed, he had no knowledge of what was happening, and the project was still being run out of Advocate Johnson's office.
And then before you go to the next paragraph, if I could take you to file 10, page 328, because you don't deal with this in your statement. You skip to 2 June, so I would like you to just address in sequence where now this email, WhatsApp exchanges between you and Advocate Johnson on the 20th of May 2025 after the authorization, and it's an email that you sent to Advocate Johnson. If you can just read it and then you can read her response, I'll tell you where you can find that.
328.
Yes. Of file 10.
Please remind her that she has the screen available to her.
Sorry. Thank you.
If you're struggling with the files, remember it's flighted also.
Thank you, Commissioner. Morning, Advocate Johnson. Trust you are well. I need your leadership, prosecutors' guidance, and instructions on legal and evidential aspects. On Project Diversion and the link of a 28 on diversion, I ask that they not finalize the affidavit as it contradicts Mr. FK's affidavit. But this person that was a 28 interview is a listed suspect on the new matter with a strong criminal link to the offenses. Mr. Bellichin has asked PM, project manager, on the new matter to arrange a briefing with the general on Monday 26th with DD and 2 PPs. I need clarity on your instructions on how we proceed with the project. I am almost done with the report for you on evidence, just adding most recent affidavits, and I will have a draft charge sheet for HB.
That's
matter,
housebreaking.
Correct. Matter ready by Friday. I'm waiting for the last affidavit so that we can have sufficient evidence of corruption.
If you can then go to, so please advise if I may ask N02 and then go to 327, the top of 327.
Please ask, if I may, please advise if I may ask, to schedule a 30-minute meeting when you are available this week. Thank you. Advocate Johnson replies, sorry, which general must be briefed and which DD and PPs? At present, I am the supervisor on the matter, and as such, all decisions must be run by me.
Then you respond?
You have so much on your plate, sorry to add. That's why I asked you. He asked Tsepo to make arrangements with Santos Joy and myself, and he made arrangements with General Matlow to brief us. My understanding was that it must go through you, and only when you're not available to Santos. She replies, you are correct. I haven't briefed Santos yet, so they must run everything past me. I reply, noted, thank you. I will advise PM to hold on everything, and he must inform Belochin. She replies, thanks.
Now, the briefing with General Matlow, what was the purpose of that? Was it explained to you?
Briefly by Mr. Belochin, where he indicated General Matlow was going to brief us on the reports, and they were going to brief her on where they are with regards to the investigation.
And they were intending to have that sometime on the 26th of May, around about there?
Correct, and the authorization was only on the 16th of May. That is why, or how I knew that investigations had started already.
And at this stage, there's still no Section 27 affidavit?
Correct.
That you've seen?
That I've seen.
Okay. And when was General Matlow going to come to your offices? What was the arrangement going to be, and who was arranging this? Was it Mr. Belochin?
Mr. Belochin was arranging everything, and the boardroom, we were previously, we're now at CSIR, but previously we were at the Linton House, the old SARS building. So the SARS boardroom was booked.
Okay, so then it seems that there's a meeting that's held on the 27th of May, but I don't think that's the one with General Matlow. If we go to page 51 of file 11, which is your written notes.
Sorry, what page again?
Page 51 of file 11. We had dealt briefly with this. I just want to deal with it in sequence.
Correct.
There's a reference there. So this meeting, it says Brian, Dylan, Tsepo, Pat, Charles, ID, and you, of course. And there's a reference to Tembisa. Would that be now what we know as the Medicare 24?
Correct. It was at this point that it was started, the name of Project Wellness was given.
Okay, we'll get to that one. If you go to the next page, here there's a discussion about search at the house, J51, all on one day. What was that about?
Advocate Johnson indicated that name or the designation needs to be changed to include the name of the service provider that would be present for the seizure of the cell phones, and that the search must all happen on the same day. So they must search Mr. Matlala's house and obtain the devices on the same day.
And then on the next page, the top entries.
Advocate Johnson asked questions with regards to General Matlo's report. The questions were, has the minister received the report? What usually happens after a report like this? Requests are complete. And forensic investigation, who, how, when will it be finalized?
Why was she asking these questions? What was
Because
the
I
point?
had raised it.
Okay, you had raised the questions about General Matlo's report.
Correct. My question with regards to that was, how are we investigating based on a preliminary? And then there's still a finalized report that needs to follow that might or most probably affect the investigation as it stood or continuing.
Okay, because at that stage you just had the report that stated, at that stage did you still only have the the report that saved as 30 January 2025?
Correct.
Okay, you didn't have the April report yet?
No.
Okay. And then on the next page, page 54, there's a reference to General Matlo again. What was that?
Advocate Johnson had indicated that she wanted to be present with, in the meeting with General Matlo. It was supposed to take place at Fire and Ice at 10 o'clock. It did not, that meeting did take place, but General Matlo did not join.
So that would have been still on the 27th?
It would have been between the 27th and the 28th.
Okay. And then the next page, there's also a reference, third line, ask General Matlo.
With regards to this, it was because NASCOM had commissioned this internal audit. My understanding was that NASCOM had given General Matlo access to all the bid documents and files with regards to the tender. And so it was a question to ask Matlo to release that information to IDAC, those files.
And then the next entry refers to Cat and Cartwright. What is that?
MJ. MJ is a reference to a witness from vetting.
It's fine, you don't have to say the witness's name.
And that witness confirmed that Cat has a personal relationship or personal friends with Cartwright.
Cat would be Mr. Matlala.
Correct.
And Cartwright would be Cartwright in respect of that has been charged in the Medicare 24 matter.
Correct.
Okay, one of the suspects. And was this witness, one of the MJ, was this a witness that was from the crime intelligence wing investigations as well, or hadn't featured there?
It is a witness from the crime intelligence matters, from the vetting department.
And who had told you, who had communicated that MJ confirms that Cat is personal friends with Cartwright in that meeting?
It would have been Mr. Perumal because he was doing most of the talking during the meeting.
Okay. And then there's again a reference, you've got two arrows, and chain statements equal not yet done, legislation applicable, and then ask Matlo release of info. Is this the digital files that you were, the documents, the bid documents you were referring to?
Correct. Those are the documents.
That General Matlo was going to release, make available to you?
To make available to IDAC, yes.
Okay. At what stages do you know, and were you present in any discussions about the fact that a Section 27 affidavit was needed in respect of General Matlo? Because we know there's an affidavit that she deposes to in June of 2025, where she asks for an investigation to be initiated. When were those discussions held, that such an affidavit must come?
So after the July 6 media briefing, that team were trying to get what Advocate Johnson called the house in order, because there was even a meeting. I must place on record that at some point Advocate Johnson wasn't allowing me to take notes. She did say while she was testifying that I take comprehensive notes, and on a particular meeting she was like, you don't need to take notes, just listen. So not all the meetings have been documented. It's where I could take notes. So in that particular meeting, Advocate Johnson even indicated that the crime intelligence project diversion dockets cannot only be held by Mr. Padiachi. So she indicated that it must be put in the names of the other investigators, but only for the purposes of the name of the holder of the docket. Everything else will continue between Mr. Padiachi and Mr. Perumal.
Okay, so, but I'm asking, were you present in any meetings where a discussion was had that General Matlo has to do an affidavit to initiate, asking for the investigation to be initiated?
No, I was not directly involved in that specific aspect.
Okay. Then we can go to the 2 June meeting in your affidavit, page 20, paragraph 43.
On 2 June 2025, before General Matlo deposed to the affidavit of 6 June 2025, a meeting was held on the Medicare 24 matter, where General Matlo was present. This was highly irregular for obvious reasons, but her presence was justified by Advocate Johnson. I have been unable to retrieve these notes. They were at the office, and I have not been able to return to the office since.
I think, just to clarify, you do have notes for 2 June 2025, but not all the notes for that entire day.
Correct.
So if we go to page 45 of file 11, there are some notes that deal with the Medicare 24 matter. So maybe you can just take us through that. Page 45 on file 11. We see wellness at the top. What is that?
That is the name of the project, Project Wellness.
Which is the Medicare 24 investigation, okay?
The first aspect that was discussed, and Commissioners, this is now the 2nd of June 2025. They are already discussing that Mr. Matlala is a possible 105A, meaning plea agreement, which then...
At this point, had they spoken to him, to your knowledge?
The way they were conversing, it was almost as if it was already a done deal.
Okay, but you didn't know whether they had engaged Mr. Matlala?
No, I don't have knowledge about that.
Okay. So you're saying at this stage they were already discussing the possibility of Mr. Matlala, of entering into a plea and sentence agreement with Mr. Matlala?
Correct.
And had they discussed what the nature of that would be?
No, that discussion didn't take place in detail.
Okay. You can refer to your statement or the notes, whichever, but on paragraph 43 you deal with that meeting on page 20.
I had a huge disagreement with Mr. Perumal regarding the aspect of the matter, which I cannot disclose before the Commission at this stage because the matter is currently scheduled to proceed to trial. Another bone of contention between Mr. Perumal and me was the issue of Section 204 engagements with Mr. Mike van Wyk. I wanted to know how Mr. Bellichin could have already met with Mr. Van Wyk when the authorization had just been granted on the 16th of May 2025 and already progressed to the point where Mr. Van Wyk was being considered as a 204 witness at the time of our meeting. In fact, there is no 27 referral affidavit. There is a preliminary report at that stage. I'm not aware of a final report. And yet, there are engagements for, for arrangements on a potential Section 204 witness. I said this cannot be. I was invited to a meeting with Mr. Van Wyk and his attorney on the 28th of May, but I did not attend.
We can go to that page 615 of file 10-2, which is an exchange between you and Mr. Bellichin on, so part 10, part 2, page 615. I wasn't sure of the date, and I don't think you came back to me on the date, but it would have been around that time because the screenshot doesn't have the date, so maybe...
It was between the 27th and 28th of May.
Okay. And we see here that he says, I think the third white block, he says, will do, please avail yourself for the meeting with Mike. Is that Mike Van Wyk?
Correct. I replied, I have a meeting with the ID now. Did Mike, and then later on during the day, I sent a message at 13:43. Did Mike come? His reply is no, tomorrow at 12. Please be available tomorrow for the meeting with Mike and his attorney. I need your pitbull approach. I reply, I really need to finish drafting.
So you didn't want to attend the meeting?
No, I did indicate on Tuesday that I found every excuse not to go to meetings after a certain point.
Then we can go back to your statement, paragraph 44 on page 21.
General Matlow then informed us of the developments regarding the internal investigation, which really did not shed light on the matter because the preliminary report had already been disclosed. I do not know when General Matlow's 6 June 2025 affidavit was submitted to IDAC, but in it, she calls for an investigation to be conducted when she already knew that Advocate Johnson had approved a Section 28(1) investigation, because Advocate Johnson had told us in her email in May 2025 that she received a call from General Matlow and that she, being Advocate Johnson, wanted to authorize the Section 28(1) by 16 May 2025. There was no further discussions regarding subpoenas.
There were further discussions.
Sorry, there were further discussions regarding subpoenas and bank statements. But after that meeting, I completely excluded myself from the investigation. I would find excuses not to attend any of the Medicare 24 meetings. If I may just explain or expand on the statement about the subpoenas and the bank statements. I had gone at length to explain you cannot start an investigation with a 204 because the 204 is going to mislead you. You need to investigate and then approach. So in this meeting, Mr. Van Wyk had provided 3 bank account details for Mr. Matlala. And Mr. Bellichin had indicated they were only going to subpoena those accounts. And I said, no, you cannot do that. You have to send a subpoena to all the banks with the ID number because we are dealing with money laundering. We cannot go on the 3 bank accounts only that are provided by someone who's also implicated. And Mr. Bellichin said to me, if that, I'm doing this my way.
And so that's again one of the issues that you have with him, that he just does his own thing without prosecution involvement.
Correct. And no matter how you complain, nothing changes. That team pretty much does whatever they want. And if you complain to Advocate Johnson, I have explained what happens.
Could it not be said that because she was in charge, I mean, she's a prosecutor, she was in charge of this project, so they were doing it with her directions. They may not have listened to you, but the person in charge clearly they were engaging with.
I gathered so.
Okay, we can then move on to another topic, which is prosecution memo on General Masemola and General Kumalo, page 21, paragraph 45 of your statement.
Sorry, maybe before you do that, and it may be that you're dealing with it in this very next heading, the report, the audit report, to my recollection, does not make any allegations or accusations of General Masemola.
No, nothing of, not even the final report.
Yes. Now, and then it takes me to my next question, which is really more a process question, that is there any reason that you would have excluded, when I say you, I mean IDEC, that you would have kept the National Commissioner in the dark, where you are looking at Medicare 24 based on a report that doesn't make any allegation against him? In your operation, how does that work in your operations?
Commissioner, once again, you're so far ahead of us. I do deal with that with my notes on the 8th of July.
You'll deal with it when you get there.
Thank you.
Okay. 45.
After the arrest of General Lushaba and 3 others, and thereafter General Kumalo and others in the Mukwele matter, we were in the process of moving officers, yet the pressure to enroll matters against General Masemola and General Kumalo did not ease. There were already draft J50 affidavits for the arrest of General Masemola and General Kumalo in respect of the appointment of General Kumalo to Divisional Commissioner of Crime Intelligence. It was sent to us on the 2nd of July, 2025.
Can we go to that document, page 500 of 10, part 2? It's an email from Mr. Perumal to you and Advocate Lashwayo regarding Brian affidavit.
500.
Yes.
Oh, thank you.
So it's at the 2nd of July 2025, 11:13:34, high attached as requested. And I think we will see later why you probably requested it on that day, because you were busy preparing a memo.
Correct.
Okay. So we then can go to the document on page 502, which is an affidavit by Mr. Pariachi, a draft, in support of an application for a warrant of arrest in terms of Section 43 of the Criminal Procedure Act. And he gives in paragraph 1, I am tasked with the investigations of a case docket referenced Pretoria Central CAS no number 06-2025. Why
Correct.
would he do that?
At this point, they were opening, my apologies, they were opening new dockets. They were not going according to the dockets that were referred to IDAC by Mr. Fadil. So he had left that space open. But commissioners, if we take note of the fact that, of what I said on Tuesday, this is coming from Mr. Perumal in the Eastern Cape, drafted in the name of Mr. Padiachi.
Okay. He says at paragraph 4, so it deals with IDAC, and then at paragraph 6, I therefore bring an application for the authorization of warrants of arrest in terms of Section 43 of Act 51 of 1977 for the 7 suspects whose details appear in the attached J50s and who summarily are Sitlale Fani Masemola, Leneo Nkua, Sydney, I think he meant to say Samuel Dumisani Kumalo, Timothy Moyana, Gerhardus Jacobus Kemp, Abram Kibitle Secheri, and Ntuseng. I won't say the surname.
Correct.
Okay. And those were the suspects that he had prepared a J54 on the 2nd of July.
Correct.
Now, just take us back to the process under, so this would have been under what leg of operation diversion?
It would have been leg 3.
which is the Masemola Kumalo, the vetting.
It's the appointment of General Kumalo by General Masiamula without General Kumalo having his security clearance. And there were flimsy allegations about General Masiamula asking General Khan about how he, to just follow up on the process.
We'll get to the detail of it when we look at your prosecution memo. At paragraph 7.1, we can see the background of the case. He talks about that it's regarding the unlawful appointment of Kumalo.
Correct.
Okay. And then he talks about, on page 505, the vetting and appointment of Kumalo as divisional commissioner. So he sets out everything in his affidavit.
Correct.
Okay, and the intention was that he would use this for purposes of getting the warrant of arrest.
Yes, and Advocate Schlatzwayo and I were being put under immense pressure to start drafting the in-consultation note, the prosecution memo, and the charge sheet for enrollment.
And the prosecution memo was necessary because you needed to support the J50.
Correct.
As the prosecutor.
Correct.
Could it go ahead without your prosecution memo? Forget about Advocate Johnson pulling rank, but the normal process.
No, the normal process is that you have to put in a prosecution memo as to support the evidence, or rather, to show that the evidence obtained in the docket supports the offenses that you are preferring.
Okay. So we'll come back to this. Let's go back to your statement so that we can understand. You get this email with this affidavit in support of a J50 for the arrest of, amongst others, the National Commissioner. Correct. And the Divisional Commissioner of Crime Intelligence.
Correct.
And so you say you and Advocate Lachwayo then meet. So you can continue from there.
On 2 July 2025, Advocate Schlatzwayo and I met to discuss the case regarding the appointment of General Kumalo.
I just want you to elaborate on this briefly, because when you were discussing it with me in consultation, you elaborated on what the relationship was like at the time between the two of you, and why why it is significant that the two of you got together to prepare this memo.
Advocate Johnson ran the office as divide and conquer. You're scared to even speak to your colleague because you don't know what gossip or twists. So it's a very uncomfortable, toxic environment where we just don't trust each other. So Advocate Schlatzwayo and I we hadn't worked together before. I didn't know where she stood. She didn't know where I stood. But when we were being forced to do these things, she and I had a conversation. The conversation went along the lines of, these guys are going to ruin our careers. These are HR matters. We are not putting it on the roll. It is then that we decided on the 2nd of July to meet and attend to the memo.
Okay. And you can then, so you meet to discuss the case regarding the appointment of General Kumalo, and at the time there was a lot of distrust created by Advocate Johnson. And then, however, we knew that we had to make our views known on these matters. So you can start from, we discussed the evidence.
We discussed the evidence and agreed that there was no prima facie case against the generals. In fact, we were both of the view that something was amiss on the part of Advocate Johnson, Mr. Perumal, Belochin, and Padiachi. We decided to prepare a prosecution memo for Advocate Johnson, setting out our analysis of the evidence. Our recommendation was that there was no prima facie case. This was not the first memo that I had prepared regarding the crime intelligence matters. Prior to the arrest of General Kumalo and others in the Mokwele matter, I had commenced drafting a memo indicating that there was no prima facie case against the accused. Unfortunately, I fell ill. I could not finalize and submit the memo. It is also for this reason that I was not aware of the enrollment of the Mokwele matter and arrests. Returning to the memo of 2 July 2025, we submitted the memo to Advocate Johnson on the same day. And to our utter surprise, she agreed with the assessment that there was no prima facie case.
So can we go to first the email and then the memo, page 379 of file 10? Just from a timing point of view, so while you find the page 379, you get the affidavit of the draft affidavit of Mr. Pariachi that morning, Wednesday, and at 18:47 that same day, you send a prosecution evidence report, vetting and promotions leg 4. You say it is to Advocate Johnson, the project manager, Mr. Sissoko. You have Joy in there, and then the PA of Advocate Johnson.
Correct.
Okay, you can read the email.
Good evening, ID. Trust you are well. I apologize that we could not submit earlier. We only finished drafting at 5 p.m. Attached is our combined report and submissions after careful consideration of all factors. Kind regards.
Now, had Advocate Johnson expected you to submit this report because Mr. Pariachi had his draft affidavit for the J50, or?
Advocate Johnson was expecting us to submit the charge sheet in a prosecution memo showing that there is evidence linking it to the offenses, or elements of the offense, and the in consultation note for the DDPP.
Okay, so she was expecting to get a document that was supportive of the J50, essentially. Okay. And then if we can go to the memo on page 382, and we'll just highlight certain aspects of it. You can read, so it's memorandum, prosecutor's report, evidence, vetting and promotions. Title State Advocates 2 July 2025. It's from you and Advocate Hlachwayo, invest to Advocate Johnson.
Correct.
Just read in paragraph 1 the purpose.
The purpose of this memorandum is to make submissions to the investigating director, ID, regarding the lack of material evidence in leg 4 of project diversion. My apologies, Commissioner Kumalo, it's leg 4, not 3.
Yes, leg 3
He was
is
going
Madondo.
to correct you
Leg 3
later.
is Madondo.
Yes.
Yes. Okay. It's just because of the order in which it was done, and you explained that in your memo, why it's leg 4 first. So let's do that, paragraph 2.
In summary, the prosecutors were informed that a decision was taken to move forward with leg 4 before leg 3, and that a charge sheet and all accompanying documents were to be drafted. This was communicated to us on Friday, the 27th of June, 2025, by Chief Perumal. Below is a summary of the statements contained in the docket and evidential flaws. It is our submission that there is currently no prima facie case, thus there is currently no reasonable possibility of a successful prosecution.
Now, can I just understand, were you told why there was this change in order, why you were going to do leg 4, which is the arrest of General Masemola with General Kumalo, amongst others, as opposed to leg 3, which would have been the primary suspects there was General Kumalo and General Madondo?
No, there was no explanation. It was just Mr. Perumal telling us this is what the ID wants.
Did you have any idea, did you have a suspicion as to what it could be?
If I keep voicing my suspicions, I'm getting into trouble. And I'll go back to my first statement, I think it was paragraph 59, where I said there was an orchestrated attack. And there was issues or complaints by Mr. Padiachi and Mr. Perumal and Advocate Johnson at the time that NASCOM, General Masemola, was not acting on suspending the CI7 accused.
This is after their arrest?
Yes.
Okay.
And this would make sense because it was communicated to you. Say the decision to move leg 4 up was communicated on Friday, the 27th of June, which would have been after the arrest and after the first appearance.
Correct.
Okay. And that is a decision that was, did you know who took that decision? I know it was communicated by Chief Perumal, but do you know who took that decision?
Mr. Perumal said that it was instruction of the ID, being Advocate Johnson.
Okay. We're not going to do the summary of all the witness statements, but can we do the A1? That is Mr. Adams.
Correct. A1, Fadil Adams. He received anonymous information that Divisional Commissioner Masia Mullah...
You mean National Commissioner?
Sorry, National Commissioner. It's supposed to have been National Commissioner. Masia Mullah appointed Khumalo to head of crime intelligence, and that Becky Cele, who was then the Minister of Police, was involved while highly skilled generals were overlooked.
Did Mr. Adams tell you who the highly skilled generals were that were overlooked?
No.
Okay.
Further, that Khumalo's vetting was allegedly fast-tracked by Masia Mullah, and that Masia Mullah knew that Khumalo did not have top security clearance. That he suspects vetting process was manipulated in favor of Khumalo. He further states that Khumalo worked as a captain. He had no skills or experience in CI at senior management level.
Then you can do the A3?
A3 is a general,
Yes.
Feroz Khan.
Yes, don't forget it is general.
He is a major general, CI, head of counter and security intelligence. He is responsible for national border security and counterintelligence, inclusive of vetting section and the counterintelligence investigations. He was not involved in the vetting process of Khumalo. He was contacted on the 28th of November 2022 on an urgent basis to see NATCOM, Masia Mullah. I was instructed to check up, we are now quoting from his statement, I was instructed to check up on the TSC, top security clearance, of the incoming DivCom Khumalo, and I was asked to give him support. Did not contact anyone at his office, found this conduct to be unprofessional and improper.
Meaning he found General Masamola's conduct to be unprofessional.
Correct, and improper. Further states that Lushaba was acting DivCom and that the post could not be filled as Lieutenant General Jacobs was removed and temporarily placed in another post by previous NATCOM, Sitole, due to internal disciplinary and criminal proceedings. If I can just clarify, this Lieutenant General Jacobs is the same Lieutenant General Jacobs that the dockets were collected from at Inspectorate.
Okay.
He indicates he does not know what informed Masia Mullah to appoint Khumalo, as he did not have top security clearance at that point. He states that Masia Mullah knew that Khumalo should have TSC as a senior manager. He further states that Khumalo did not have managerial experience within, it's supposed to be Div of CI, and it raised his concerns.
Then there's an A4 by Dimpani, who's now, it's the General Dimpani, the current acting National Commissioner.
Correct.
And it is, I think it is in the form of an information note. If you can read from, she was concerned that the post.
She was concerned that the post in question was critical. It was a critical post dealing with CI, within CI, dealing with sensitive intelligence and secret service accounts. Khumalo did not have TSC. He called, or she called Nsia, could not get hold of her, then contacted Major General Al Govender, who indicated that the TSC is to be obtained within 6 months of appointment, if already not in possession of one.
Okay.
She signed off the info note.
Then if we can go to...
Can I just ask, was there an explanation why there would be a witness statement from the Chief Financial Officer on this HR matter? Did anyone offer an explanation why General Dimpani was invited or offered, whichever it was, to submit a statement?
This is corridor rumors that Lieutenant General Dimpani, Ms. Dimpani, was friendly with Mr. Perumal, and so she was being cooperative in the investigation.
Thank you.
Okay. Then if we can go to 385, And I'm looking at the A8. We're not
Colonel?
going to deal with the A7 because I think the A7 is the 204.
Yes, correct.
Yes. A8?
Colonel, he's off the polygraph unit, received a request to attend to a polygraph test the next day. He merely indicated that he replied that he was available, conducted polygraph, and Kumalo passed.
And then the A9?
Ian Cameron, on the 2nd of April 2025, DivCom appeared before Portfolio Committee, and that he stopped questioning because there was no evidential value. However, he believes that the NATCOM deceived the committee. However, the minutes of the committee inquiry was not provided to the prosecution team.
And then we can...
You say DivCom. Is that DivCom or NetCom? Should we be making a correction? Because in the same paragraph you refer to NetCom.
Yeah.
It's NATCOM.
Okay.
Thank you, Commissioner
Thank
Baloyi.
you, Commissioner Baloyi.
So the correction is that under Ian Cameron 2/4/2025, it must be NATCOM, not DivCom.
Correct.
And then if we go to 386, your submissions.
4.1. No other statements say or confirm that fast tracking is irregular or uncommon. None of the other affidavits confirm that there was manipulation of the vetting process, only that it was made a priority and sped up. A1 statement is merely hearsay. A3, Feroz Khan says that he was contacted to go and see the National Commissioner and that he was instructed to check up on the top security clearance on the upcoming Divisional Commissioner, but was not asked to manipulate or interfere with the processes.
You say Fazal Khan, you mean Feroz Khan?
Yes.
Correct.
Because Fazal is from the IGI. And that's the surname.
We were typing as fast as possible to submit.
You're forgiven.
That he was contacted to go and see the National Commissioner and that he instructed him to check on the top secret security clearance on the upcoming Commissioner or Divisional Commissioner, but was not asked to manipulate or interfere with the processes. A3 indicates that he found the conduct of the National Commissioner to be unprofessional and improper. However, he does not elaborate on why it was improper. A3 indicates that he does not know why General Masiamola appointed Kumalo in the post as he did not have the security clearance at the time. Furthermore, Kumalo did not have senior managerial experience within crime intelligence, and that raised his concerns.
Ms. Nube, are we doing, excuse me, are we doing all of them? I will tell you why. When Advocate Johnson was here, she was referred to the Public Service Commission report. And she already conceded that because Public Service Commission dealt with the same issue in 2023, IDEC should not have dealt with it. Now, because here it's 2025 and they are dealing with it, although they say there's no prima facie case, I'm just wondering what the value of still dealing with it is.
You'll see when you get to the meeting of 8 July, there is a clear indication that Advocate Johnson, although she agreed with this report and their findings, that she still wanted the investigation to continue, notwithstanding that the prosecutors had said there was no prima facie case. So that is why I just want them to deal with it, because these same things are then raised again, which she agrees with. You'll see her signature at the end, but in the later meeting, she revives it. So that's why I wanted her to deal with it. But she can just go to, I guess, the last one, which is 414 and 416, and then the conclusion.
A7, despite being a 204, does not indicate any of her actions were unlawful, nor does she indicate any of the actions in the vetting process were flawed, nor does she indicate that there was any irregularities in speeding up the process. A8 does not suggest that request to set the polygraph on the next day is irregular or unusual. He merely states that when he received the request, he indicated that he was available. A10 does not indicate that the processes followed were flawed or irregular. He merely indicates that it was unusual for that person to call the applicant directly while the panel was sitting and request outstanding documents information. He merely states that they will usually reconvene after obtaining the documents. Before I move on, Commissioner Khumalo, if we take note of the listed suspects on the J50, the draft J50, there was mention of the PSC report. Mr. Perumal repeatedly indicated, because I wanted to read it and I still don't have it, Mr. Perumal repeated that Kemp lied in that report, and that's why he was supposed to be a suspect in this matter, because none of the statements even speak to Kemp.
Okay, thank you. Then your conclusion?
We submit, based on the above, that there's no prima facie case and no reasonable prospect of successful prosecution at this point. Signed by Advocate Schlatzwayo and myself, State Advocates, on the 2nd of July, 2025.
And then I think you must just place on record that there is a version of this document that was given to Advocate Johnson, and she, in manuscript, said that she agrees with you that there's no prima facie case.
Correct.
And that was dated the 4th of July, yes. So the one that's in the bundle is not the one that has, and we will include that one in the bundle, where she has in manuscript that she agrees with your recommendations.
Correct. She did, however, she backtracked on that agreement.
Yes. And then this was, she asked you to send it to the team. So if we go to paragraph 46 of your statement, on page 22.
Thereafter, we emailed the memo to the entire team. Mr. Sissoko called us being Advocate Schlatzwayo and myself, shortly thereafter, and told us that Mr. Perumal was calling him spitting fire regarding the memo that had just been emailed to the team. According to Mr. Sissoko, Mr. Perumal threatened to resign because they had worked so hard on the case to get it ready for enrollment, and then we derailed the entire process. Advocate Johnson sent an email on the 4th of July, 2025, effectively responding to Mr. Perumal's reaction to the memo.
We can go to that email before you go to this display. It's on page 457 of file 10, part 2.
I'm sorry, which page?
It's 457, Chair, 457. Of file 10, part 2. It's an email from Advocate Johnson on the 4th of July, 2025 at 1:35 p.m. And she's copied a whole lot of people in there. Importantly, Mr. Belochan, Mr. Padiachi, yourself, Mr. Perumal, Lashwayo, Mr. Sissoko, and yeah, those are the important ones I wanted to highlight. Subject diversion, you can read it because it's an important email.
Colleagues, we'll schedule a meeting for Tuesday and it's in person. You will attend. Before you come to the meeting, I want to remind all of you of the following. You work as a team. When you don't agree, I suggest that you engage constructively. We deal with evidence, not assumptions or personalities. IDAC is prosecution-led, and where advocates request evidence to be obtained, it is not an investigator's discretion to ignore it unless there is a very good reason why that evidence cannot be obtained. No matter how experienced we are, we must always listen to others in the team. At no stage must it seem that cases in IDAC are part of some kind of witch hunt, and our integrity and objectivity must always be at the front of what we do and say. Mrs. Sissoko and I will make final decisions, but these will always be fair and objective and based on facts. When prosecutors have to make decisions, they must apply their minds only to evidence, and that would be evidence in the docket or case file with supporting documents. It saddens me that time and again, Mr. Sissoko and I have to intervene because personalities in this team are too big for the work at hand. You all have a role to play. You all bring experience to these really difficult cases, and the ID expects only the best from every team member. I suggest you all read this email many times before you come to the meeting. Do not engage me or Sissoko on this email. You will be able to engage all the issues at the in-person meeting on Tuesday.
I mean, when you received this, it must have been a very refreshing email to receive from her, that she was supportive of your decision, you and Advocate Hlashwayo, not to continue with the matter of General Masemola and General Kumalo.
We were relieved, yes, but it was short-lived relief.
You say she supported and accepted your conclusions. This is the email you're referring to, or is there a separate standalone decision?
Yes, Commissioner Baloyi, we indicated that the memorandum that we went through, there is a version with Advocate Johnson's manuscript where she writes that the ID is supportive of this. There is no prima facie case, and it's dated 4 July 2025, which we will include in the bundle, because that was the hard copy that the witness had. This was the attachment to the email.
Thank you.
So we can go back to your statement, paragraph 46 on page 23, this display.
This display of sound judgment by Advocate Johnson was regrettably short-lived. I do not know why Advocate Johnson agreed with our memo. It was the right thing to do, and I hope that that is why she agreed with us. However, there is also the real possibility that, one, Advocate Johnson was aware of the optics of arresting the most senior SAPS officials and one of the most senior SAPS officials so soon after June 2025 arrests, or Advocate Johnson had been made aware that there was something brewing and she needed to hang 10. But again, it is pure speculation.
When you say that something was brewing, what are you referring to? We're now on 4 July 2025.
In the meeting on the 8th of July, Advocate Johnson mentioned that
Wait, you're going to spoil it. Let's go to it. File 11. Page 62. It is the second entry. You will explain to the commissioners later about this meeting, but since you've mentioned this now, you can explain your note on page 62, the second one, after on hold for 2 reasons, one, and then the second one.
KZN Mkonazi
Gauntlet. So you can go now back to...
That's cryptic. Explain.
Yes.
Advocate Johnson had at that time, I'm going to deal with the 4th of July first. At that time, we didn't know what was at play. Advocate Hlatswayo and I were in the dark. We were just assessing the evidence. Although we did feel that there was something off, and we did say that these are HR matters that we are now being dragged into for SAPS. But on the 8th of July, Advocate Johnson mentioned on 2 occasions that Khan said this was going to happen, Khan said this was going to happen. So we took it to mean that General Khan had already alerted her to certain things. Because she said, her words were, he keeps telling us that something big is coming, and then FO, or FA.
Which means, don't say the word. But she's meaning that it doesn't happen?
Nothing happens.
So prior to 6 July, Advocate Johnson had indicated that, was it General Nkwanazi specifically, or was it General Khan that was saying to them something big is going to happen and then nothing happens?
It was General Khan that was informing Advocate Johnson something big is going to happen. Because in the 8th of July meeting, she also said, he keeps saying they're coming for me.
Okay. And her reference earlier on when she says, but then nothing happens, is it's not the first time he's warned them. So she didn't think much of it, or she would take his advice and not do anything because something big was going to happen?
No, she voiced her exasperation of the fact that he keeps messaging that something's going to happen and nothing happens.
Okay. So we can then go back to your statement, page 23, paragraph 48, and it's the General Kumalo and General Madondo warrants.
May I please ask for 2-minute comfort breaks? I can take my medication.
Okay, sure.
Let's adjourn. You'll indicate when we are ready. Thank you.
Thank you, Chair.
Thank you.
Ms. Ramsamy, we're on page 23 of your statement, paragraph 48.
Thank you, Chair. and
It's the
Commissioners.
General Kumalo and General Madondo warrant.
As I indicated, the display of sound judgment by Advocate Johnson was short-lived. On 7 July 2025, Advocate Schlatzwayo and I prepared another memorandum for Advocate Johnson in respect of the Kumalo and General Madondo matter. We concluded that there was no prima facie case against the generals in this matter as well. We did not receive a response on that day. Instead, Advocate Johnson called a team meeting. She did not immediately address our memo, but later indicated that since we were of the opinion that there was no prima facie case in both matters, she wanted a report from both sides, meaning the investigators on the one side and the prosecutors on the other side, and then she will decide. Mr. Perumal refused to prepare the reports.
Can we just go for the record to the second memo, which is on the email that you send is on page 537, file 10, part 2. And it's 7 July 2025 memo.
Sorry, what page?
File 10, part 2, page 537. It's an email 7 July 2025 from you to Advocate Johnson and Mr. Sisoko, and it says Prosecutor's Memo, Leg 3 Diversion. Good afternoon, ID. This is a soft copy of the document submitted earlier, so you had taken a hard copy to her.
We had submitted a hard copy, the original signed copy by both Advocate Schlatzwayo and myself, and handed it to her PA.
Okay, and then at 539 we have the memo. Maybe if you can just read, I think, the purpose, the background, and the A1 statement.
The purpose of this memorandum is to make submissions to the investigating director, ID, regarding the lack of material evidence in Leg 3 of Project Diversion. Background. In summary, the prosecutors have perused the docket containing all statements obtained to date and summarized below for Leg 3 of Diversion. It is our submission that there is currently no prima facie case. Thus, there is currently no reasonable prospect of successful prosecution. However, we include outstanding investigations.
What were the outstanding investigations?
It was investigations that we had asked Mr. Padiachi and Mr. Perumal to attend to.
Page 541.
546. And
541.
541.
I think.
No, the outstanding investigation that we attached was 545.
Okay.
And 546.
545 and 546.
Correct.
So explain that. Oh, that is your 546. I see questions for section 28 interview, and then you have interview questions. And on page 547, you say these questions are not exhaustive but must be answered in the interview and explained in full and clear details in the affidavit. This document is not to be shared with any other person except team members and not to be given to the persons who are being interviewed. So you wanted these to be addressed even though at that stage you thought there was no prima facie case?
No. This question or document was submitted in April already of 2025.
Okay.
And the purpose of this document was to determine whether the processes of the vetting had been flouted. And the only way we were going to understand if in fact there was any corruption or flouting or whatever the case must be, was to understand the inner workings of SAP's HR.
Okay, I'm with you. And so your memo was saying they must conduct, that I think is at 541, further investigations, and at 542, paragraph 505.4, please see the sheet of previous instructions drafted and shared to the investigators in April 2025 for questioning.
If commissioners will also note that in 546, there's also questions relating to the Mokwele matter that remained unanswered.
Okay, at 546.
546.
Okay.
With 545, there's section 2, capital A, 8, A and B, with regards to Major General Mudondo. It's in relation to the National Strategic Intelligence Act. It says that Major General Mudondo has 60 days from the date on which the applicant is informed of the decision, meaning that she was refused to security clearance, in order to appeal to the Office of the Minister of Police. How are you going to charge someone if you don't have confirmation whether it has been referred and what the outcome of that referral is? So that is why we included this as well.
Okay. Then if we can go to 541, which is your submissions, instead of going through the affidavits. 541, 4.1 relates to the A1, which
Correct.
is Mr. Adams again. You can read that.
He is just raising concerns and opinions that the procedures and policies were severely undermined, which makes the statement hearsay. Further, A3.
A4, you can read the A4. A3 was General Mkwanazi, and A4 is General Khan.
His statement takes this case no further, as it provides an explanation of vetting processes and deals more with his own current situation than the case at hand.
What did you mean by that?
That affidavit by General Feroz Khan spoke about how General Khumalo had refused to sign off on his vetting or security clearance, as opposed to the issue of Mudondo and General Khumalo allowing Mudondo to continue working without clearance.
Okay. And then we've done your submissions. You can just then read the conclusion at 542. We submit.
We submit based on above that there is no prima facie case and no reasonable prospect of successful prosecution at this point.
Okay, so that was on the 7th of July that you submitted it to Advocate Johnson. There's no response, but she calls for a meeting on the 7th for the 8th.
Correct.
Okay, and the purpose of that meeting is to discuss what? Because now we know that the 6th July press briefing of General Mkwanazi has happened.
Advocate Johnson gives us various instructions on the meeting of the 8th of July.
My question is, did she tell you what the purpose of the meeting would be?
In her email?
Yes.
No.
Okay, so then we can then go to your statement on page 24, paragraph 49.
To date, we have not received a response to our 7 July 2025 memo. However, I must state that our memo of 7 July 2025 relates to the very matter wherein IDAC had intended to arrest General Khumalo and General Mudondo in June 2026, which has been widely reported in the media. These warrants have since been held in abeyance. I am not aware of any new evidence that could have justified the issuing of these warrants after our memo.
Were you replaced as prosecutors? What happened to you and Ms. Latwayo, Advocate Latwayo? Because the memo was by the two of you, so I assume you were the prosecutors appointed. What happened? Were you replaced by other people?
We were replaced by a different team or a different prosecutors under Advocate Santos Manila.
And you don't know if that team prepared a new memo disagreeing with your memo?
We were not even allowed to communicate with them. So in essence, Advocate Johnson didn't even want us to tell them that we'd prepared a memo, that there's no prima facie case.
Okay, you can continue in 49. This just further demonstrates to you, I think you must say.
This just further demonstrates to me the determination with which this project was conducted. In my view, the intention was to target General Masiamula and General Khumalo until they were no longer in office. The attack against General Masiamula may have intensified when he did not suspend General Khumalo and the other accused in the Mukwele matter after their arrests. Because during the 8th of July 2025 meeting, Advocate Johnson made her position clear regarding General Masiamula.
And then we now go to that meeting of 8 July 2025, and this topic is further instructions regarding General Masemola. For this, I'll ask the commissioners to go to file 11, page 60, which is your notes, your written notes, handwritten notes. And you can just tell us who was present at that meeting before you deal with what was discussed in the meeting. So, are you on page 60 of file 11?
I am.
Okay.
Present at the meeting is the ID, Sissoko, Joy, Sunil, Dylan, Brian, Tsepo, Pat, and Charles.
And you, yes. Okay. And it's diversion?
The first part of the meeting was diversion. If I can just elaborate on how the meeting started. Advocate Johnson said the day before, on the 7th of July, Advocate Johnson had made a comment to Advocate Schlatzweiler and myself, saying that she can see that Mr. Perumal is bullying Advocate Schlatzweiler and myself. However, when she started, and she was going to deal with it in the meeting the next day. However, on the 8th of July, the meeting started with, I'm not going to deal with the meeting how everyone thinks I'm going to do it. And Advocate Schlatzweiler and I were chastised or scolded for and made to give an updated report on the two matters that were in court.
Meeting, is any one of these people a DDPP?
No.
Thank you.
She had given us instructions with Lushaba that on or before the 30th of July, it must be signed off by Sissoko on a letterhead, and that the index of the docket must be disclosed and signed off by Chief, being Mr. Perumal. So there was...
Was that regular practice that the investigator would sign off on what is discovered?
No, Commissioner. It's also not procedure that we don't get the original docket, but when it comes to that team, we only get scanned copies.
Yes. And who would sign ordinarily, sign off on what gets disclosed?
The indexes that I've done, it's myself and the investigator that would sign off on the index itself.
Thank you.
Okay, I think you can go to your statement and we'll display your notes so you can read from paragraph 50.
At the meeting of the 8th of July, 2025, Advocate Johnson, amongst others, instructed us as follows. The only person who can veto Mr. Perumal is Mr. Sissoko. The case strategy is supposed to be led by a prosecutor. However, the case strategy would be led by Mr. Perumal, and he has carte blanche. In other words, the investigator was in charge of the prosecution-led investigation, and the prosecutors had to defer to Mr. Perumal. All information regarding the case strategy had to be sent to by Mr. Perumal, not the prosecutors. I think we just need to correct that. Had to be sent by, not to Mr. Perumal. By Mr. Perumal, not the prosecutors. Mr. Sissoko and Advocate Johnson would sign a letter addressed to Digital Forensic Services for a quick snapshot analysis of data on Mr. Matlala's devices.
And for that, we'll go to 62 of the notes, the handwritten notes, Commissioners, we're there now. So 50.4 is the analysis from the forensic services. The analysis had to
focus on whether any communication was found on the devices between or relating to the following persons: Minister Mkunu, Brown Mokhotsi, General Becky Cele, NASCOM General Masemola, General Sabia, General Bongani Ngwenya.
I think on your notes you have more, so it just ends on 4, but if we go to page 63 of your notes, you can explain.
Andrew Chauke, as number 7, is the DPP of Johannesburg South prosecution. Advocate Johnson had indicated that she had received a formal reference from NDPP, being Advocate Shamila Botoi, to investigate Andrew Chauke. at this point, when we are being asked to do a digital snap analysis, there's not even authorized 2813 into Advocate Chauke. And even though it was referred by the NDPP, there still needs to be an authorization. The other thing that was very concerning about number 7 is that how did Advocate Johnson or Advocate Betoy get information to link Advocate Chauke to Mr. Madlala's devices? Number 8 was the most distressing for me, and it's one of the reasons I will explain later. Advocate Johnson indicated that there must be a snapshot analysis on Mr. Madlala's phone to link Fani Masimola's daughter.
To link the National Commissioner's daughter to Kat Madlala's devices?
Correct.
Okay. Can we go back? We'll keep displaying your notes because I'm following on both, but can we go to paragraph 51?
Before I continue with the other instructions, it should be mentioned that this meeting was held after General Mkhonazi's 6 July 2025 media briefing. The name...
Sorry, Mr. Msami, let me ask about this list. Was an explanation given why there should be a snapshot view or look into, you've referred specific, well, I think with Chauke she said she had received a referral or information from the NDPP then about General Masemola's daughter. Was there an explanation offered?
Commissioner, as I've been explaining constantly, there's never an explanation, but Advocate Johnson always has this information and then she issues instructions. It's the same thing as I explained with where Mr. Hudson works and how he was supposed to be picked up. She always had the information, but she never divulged. However, I did explain that there was always undertones that Mr. Perumal Beluchin and Mr. Padiachi and Advocate Johnson knew exactly what was happening and we were playing catch up, but not fast enough.
In the meeting, she didn't say why. Are we looking at
no, she did
connection with the daughter? Thank you.
Okay, back to 51. So you say it's after the briefing, and then you say the names?
The names of Minister Mkunu Mr. Brown Mokhotsi and General Sabia had been mentioned during the media briefing. I could understand why there would be a focus on communication between Mr. Madlala and these individuals on the device, and perhaps even General Trele. However, General Masimola's name seemed misplaced to me. There was no suggestion that he was linked to Mr. Madlala. And at this stage, even IDAC's own Section 28(1) process had not mentioned General Masimola, nor had there been any links between Mr. Madlala and General Masimola mentioned. Back to the instructions. Advocate Johnson instructed that we must determine from Mr. Madlala's devices if there's any link to Advocate Andrew Chauke, because Advocate Johnson had received a formal referral from the NDPP, being Advocate Betoy. There was no further elaboration. I have not seen this formal referral. Advocate Johnson also said, that the snap search analysis on Mr. Madlala's devices should look for links with General Masiamola's daughter. Advocate Johnson then went away for a week and she wanted a full briefing the following week when she returned.
Before you go there, can we just go back to your note? There's an aspect that you don't deal with in your statement, but that is in your notes. On page 61, at the bottom of page 61, and just to highlight to the commissioners that you explained that the numbering in the bottom left corner of these notes, starting on page 60, has the number 1 in a circle. Then we have number 2 on page 61, but then it jumps to 4. You indicated there's not a page 3 missing, it's just...
My dyslexia.
Yeah, it seems to be prominent in this team here. Then if you can, so we're not missing a page, so if you can just deal with what the bottom instruction is. ID will read the docket, and this related now to, as you said, the two memos that you and Advocate Lachwayo prepared on the General Masemola and the General Kumalo matters, leg 3 and 4. Leg 4, we know that she was in agreement with you, but now here's the change, because now she wants input from the investigators. She's now wants their input as to whether there is a case, and she will consider both.
If I may quote what was said, the investigators must do a report to show and explain to the prosecutors what evidence is in the docket.
Okay, so in other words, your mind will be changed after that, or she's going to take their views.
Correct.
Okay.
The latter.
And then, but then she says, according to your notes, both sides to give report, and then you say on the next page, but this is on hold for 2 reasons. So what are the 2 reasons? That now the investigations into General Masemola and General Kumalo Madondo, why are those on hold? That's how I understand it. There's 2 reasons.
It's the correct understanding. The first is that we must do nothing else but the Matlala tender dockets. So all our concentration must be on that matter. And then the KZN Mkwenazi gauntlet. So they were waiting for the dust of the 6th July media briefing to die down.
Before they were going to revive the Masemola, General Masemola investigation.
Correct. On the meeting of the 1st of September, 2025, where Advocate Johnson strongly informed Advocate Hlatswayo and myself that the 2 matters will be enrolled.
Okay. Then we can go back to your statement, paragraph 53 on page 26.
Advocate Johnson then went away for a week, and she wanted a full briefing the following week when she returned. She indicated to the prosecutors that she no longer wanted email correspondence going forward, but preferred office notes. The office notes must be signed by the person receiving it and a copy filed in the office file. And that both dockets for the arrest of General Masemola Kumalo and General Madondo Kumalo must be provided to her office. After this meeting...
Sorry, can I just say, insofar as this instruction that there must be no email correspondence, there is also from the 1 September meeting, where Advocate Johnson repeats that instruction, that because of the Madlanga Commission and the ad hoc committee, she doesn't want a paper trail effectively.
Correct.
Can you just elaborate on that for the commissioners?
Advocate Johnson became paranoid and said that her devices were being watched, etc. Also, if there's no emails like what I'm providing to the commission now, there's no proof that these things were said or done. So she wanted to curtail it.
And she specifically referenced Ms. Advocate Sarunya's email, his detailed email from August 2025, where he challenges the merits of the case as being one such email that if it got into the hands of one of either the ad hoc committee or the Madlanga Commission, these kind of things would come back to bite you.
Correct, those were her words.
You may continue.
I sent a WhatsApp to Advocate Johnson asking to be released from the matter due to safety issues. I needed a reason to get off the matters immediately. I had to put it in a way so that I would not get forced or instructed to stay on the matter. Because when you say you want to be removed or you don't want to do something that Advocate Johnson wants you to do, she will still instruct you on the matter. I just knew after this meeting that there would be more illegalities. Why would they want to look for links with General Maseamola's daughter or investigate General Maseamola insofar as Mr. Matlala is concerned, when there was absolutely nothing pointing to any link with General Maseamola? It was clear, at least to me, that General Masemola was a target and the rules would be broken to catch him by any means necessary. All the instructions given by Advocate Johnson on that day did not sit well with me. My further concern was where was Advocate Johnson getting the information regarding the potential suspects, especially General Masemola? When we met with General Matlo regarding this Medicare 24 matter, she indicated that we would not need to subpoena General Masemola for documents relating to this investigation because he was cooperating. If that was the case, why would he be identified as a suspect in an investigation where he was cooperating without the need of a subpoena? The next day, Advocate Johnson sent a WhatsApp to me stating that she had discussed my request with Mr. Perumal and Sissoko, and that she was excusing Advocate Schlatzwayo and me from the Medicare 24 investigation in totality, except for where she would require assistance from us, then she would ask. She indicated that she herself would be the prosecutor on the matter until she finds a senior.
Conclusion.
I hope that my testimony will be of assistance to the Commission. I have not dealt with all the events that transpired in between these main events set out in my two statements, such as Mr. Rapesu's victimization regarding the Nkabinde matter, and I have elaborated on this during my oral testimony. This does not mean that this testimony is not important or less important than what is contained in my two statements. The victimization of officials in the office is a serious matter that warrants attention. In conclusion, let me say that I had to strike a balance between the good IDAC and the bad IDAC, as General Mkhwanazi had called it. There are very good people that work at IDAC and who do amazing work in the pursuit of justice. I hope that we will not be painted, we will all not be painted with the same tainted brush as Advocate Johnson and the investigators, Mr. Perumal, Padiachi, and Belochan, that she allowed to compromise the integrity of IDAC as an institution. There's just one aspect that I missed in August. On the 8th of August last year, a member of Mr. Perumal's team contacted me telephonically and had indicated that Mr. Perumal, Mr. Padiachi, and another senior state advocate were plotting to have me arrested so that I could be discredited before any commissions or committees could be established.
Thank you, Mr. Msami. Chair, that is the evidence of this witness. Finally, we are done.
I'm sorry to...
Okay, not quite.
Yeah, I'm sorry to disappoint you. I was promised that you will answer my question, and we didn't get there. I had asked you about, and it arose rather in the context of the General Matlo report, and which doesn't make any allegations against General Masemola. And then I asked a process question: under what circumstances would you keep from the head of institution or even a manager your investigations and keep them completely in the dark? In this case, the cases where the National Commissioner may not have been aware, under what circumstances, as a matter of practice or protocol even?
There should never be such an instance, ever.
Yeah. Unless, of course, they're a suspect.
Unless they're a suspect.
Yes.
But if we had to go back to the preliminary report, firstly, it was mandated by General Masemola. Secondly, during the preliminary, and there was no findings of General Masemola being involved in any form. Mm. So that is why it raised serious concerns as to why he's now being mentioned to be investigated, to be linked to.
All right, thank you. And then second question, this note that we end up with, it's on the 8th of July. So that must mean, and maybe I'm stating the obvious just for for the record, that must mean that when Ms. Johnson was testifying before the ad hoc committee, that there was never an investigation into the National Commissioner in particular, that evidence would have been false. again.
Correct, and Commissioner Beloy, it was after listening to her testimony that I contacted the DPCI again to say, I have proof in the form of an affidavit from the 1st of April
Yes.
that Advocate Johnson deceived the ad hoc committee.
Okay. Thank you. And then lastly, I think she was asked a question about prosecutions for Public Finance Management Act infractions. And this relates directly to, arises from the charges against the National Commissioner. And I don't remember the exact formulation of the question, but her answer was, we have prosecuted people for pure public finance management contraventions that is similar to what, and I paraphrase, similar to what the National Commissioner is facing or charged with. The question is there such a history, and where, and in particular, such charges not linked to allegations of corruption or charges of corruption under PRECA or other relevant legislation?
Commissioner, with regards to the matters that I have worked on and the matters that are now set down for trial, we have never charged only on PFMA. There's always predicate offenses that, and then the PFMA. So the matters that I am currently involved in with PFMA is a charge. No, we've always linked the person to something else.
Thank you.
That actually occurs with our interpretation, which we put to Advocate Johnson and I think some other witness after her. Yes.
Thank you, Chair.
Thank you, Chair. That's it for the witness.
Thank you. We may have to wait, but maybe outside, for Advocate Chaskalson. When we adjourn, if we are to grant the witness P application, we want to adjourn for the day in open session. And, Ms. Ramsamy, thank you very much.
Thank you, Chair. Thank you, Commissioners.
We truly appreciate you sitting here for days and days. Thank you very much.
Sure.
You are excused. Perhaps let's... anything to say, Mr. Ramazekisa?
Thank you, Chair, for the opportunity. I think I just have to use it also just on one issue.
Yes.
Am I getting cross-examined by my own counsel?
Not at all. We knowing how the commissions operate, you know that at some point we are afforded an opportunity to re-examine certain issues. So there is just one issue that I just want your understanding. In paragraph 52 of your supplementary affidavit, it is your evidence here that there was an instructions that was given from the former NDPP to Advocate Johnson, wherein you were given instructions to determine if there are links between the phone of Mr. Matlala and Advocate Jauke. And I'm asking this on the background that it is in the public domain that we know that there was a Nkabinde inquiry wherein the NDPP, former NDPP, was a complainant of some sort. So I want to check as to, did this instruction relates to that, or it related to other things pertaining to what we are stating here? Because for Advocate Chauke's name just to come from the blue from the former NDPP, it's just surprising.
I'm going to give you an observation that I made, but first let me answer the referral. I had seen it, but I was not able to read it. It was flashed in front of us in a meeting in Advocate Johnson's office, but it was signed by Advocate Batoy. And once again, I found the timing very, very coincidental that Advocate Batoy was asking IDAC to investigate Advocate Chauke, because it was at the time that the president was about to announce the Nkabinde inquiry. So it didn't make sense. Why are we investigating? Are we doing a parallel investigation? Or are we trying to add meat to Nkabinde's inquiry, or Nkabinde inquiry? Have I answered you?
You said you were going to answer and then you're going to have an observation. So have you done both, or?
Yes, Commissioner Kumalo, my observation was with regards to the timing.
Okay.
Thank you again, you are excused.
Thank you. Thank you, Commissioners. Thank you, Chair.
Thank you. Mr. Ramatsekisa and your team, you are also excused.
Thank you.
Thank you very much. Yes, Miss. Yes, Mr. Shaskalsin.
Thanks, Chair. Should I not wait for Ms. Ramsamy to leave?
Right,
I'm happy to move now.
I see, whilst Ms. Ramsamy is walking out, I looked at Mr. Maga. It looked like he wanted me to specifically say that he too is excused. You are excused, Mr. Maga.
Thank you, Chair. There is an in-camera application before the Commission. It's an application that was made by the witness, but which the evidence leaders certainly support. And we've received no notice of opposition from anyone. So I would just move for an order in the terms set out in that notice of motion, which would provide that the applicant's testimony is heard in camera and that the transcript, recording and documentation relating to the applicant's evidence is kept confidential.
A ruling is so made.
Thank you, Chair.
Yeah, and I assume that you will then prepare the document that is going to be signed by the Commission Secretary. Let's take the adjournment, which is an adjournment for the day, and for us to then proceed in camera.
Indeed, Chair.
Yes. And we resume at 9:30 tomorrow morning. Oh, it's Saturday. Because, I want us to finalize all the testimony now on Monday at 9:30 a.m. Thank you.